Can I just check that everyone can hear me? Thumbs up is all that we require. That's great. It looks as if we have everyone, and welcome, Trainer. We understand you had a lot of difficulty yesterday, but it looks as if you are connected today. And we'll deal with what you might have missed in a moment, and I'll ask you your views on proposal to consider you fully, even though you missed a day yesterday. I'll do that just in a minute, if that's okay, Strain. Okay. For those on the webcast, this is day 2 of a virtual hearing with regard to operational noise for the conjoined inquiry for 3 wind farms in South Ayrshire. Those wind farms are Craiginmoddie, Carrick and Knockcronal wind farms. My name is Keith Bray, one of the 3 reporters appointed by Scottish ministers to consider the 3 applications and report back to ministers with our recommendations. Mrs. Leven and Mr. Reid are also present today, and they are also reporters appointed to consider these applications. Yesterday we reached item 5D on the agenda, and in a moment we'll continue from that point in the agenda. If anyone on the webcast today wishes to hear my introductory remarks about procedures, then please watch yesterday's session. I'll not repeat it all today. I have with me today not only my colleagues, but representatives of Craiginmoddie Wind Farm, Carrick Wind Farm, Knockcronal Wind Farm, representatives from Safe Straighten for Scotland, and Ellen Trainer, who was unfortunately able to connect yesterday. All that you tell me today is evidence, and it may be included in our reports. And as you saw yesterday, we'll be taking notes from time to time. The remaining matters may take us up to 4 o'clock today, but we'll just have to see how we go. Just remember to switch off your phones, and if you do have an emergency, please address that. So, Ms. Trainer, you didn't get the opportunity to participate yesterday. My proposal is that we'd continue with the agenda, and rather than what I plan to do is just ask questions related to the matters you had raised as we went through the agenda, I propose to leave your comments, if you like, and questions that I'd like to ask of the applicants in relation to your comments till just after item 9. No, let's go after item 8. In between item 8 and 9, I'd like to take, with the everyone's agreement, that I ask some specific questions which relate to Ms. Trainer's objections, largely in relation to Craiginmoddie. So that allows me to catch up with some questions, and it allows Ms. Trainer to participate more fully after missing yesterday. And it should mean that we don't need to go through any further written procedures, that we can just have all the question and discussion today. Ms. Trainer, does that sound reasonable to you?
Yes, it does. I managed to watch yesterday.
Okay, and the applicants and Safe Straighten for Scotland, does anyone object to that? We'll take just a short break, perhaps after item 8, just so you make sure you've got the documentation. But no one has any great concern over that. We'll just have a specific item where I'll ask some questions in relation to the submissions made. Okay. It seems as if we have agreement on that in between items 8 and 9. Now to the documentation that was submitted yesterday for Save Straighten for Scotland. 2 documents and a summary and a list of points that were to be made. Ms. Crossway, could you give us an update as to whether you managed to send the documents again with the list of pointers, and then I'll ask the applicants if they received and have had time to look at it, and we'll have a discussion on those 2 documents, whether they can be discussed today or whether they will be subject to further written submissions. But you first, Ms. Scott.
Thank you, and good morning, everybody. Yes, I sent them all by WeTransfer. I also sent them to the DPEA office, so I hope everyone was able to open them. And Mr. Husson did a very brief synopsis of outlining where they are important. He didn't actually put that they actually apply to the complaints as well. They are directly linked to the complaints section. And obviously they followed on from freedom of information that had been requested earlier. Thank you.
And have the applicants received and had time to look at that?
July. So I didn't want to cut across you, sir.
I was just going to say, I know that we've not received any updated information. It was just the information that we had yesterday, although you have said, Ms. Cosby, that it has been sent to the DPA again. When it was sent yesterday, we weren't able to open it, open one of the documents, and that's still the case. We haven't had it circulated to us. But if I can talk to the applicants, whoever wants to go first. Mr. Hardy, I think we're there.
Start. Yes. I mean, we did receive the documents. We've had as much time as we've been given, although we are by no means finished with them. The synopsis was a bullet point email, and I think that isn't sufficient for us to understand what's being said. It's also the case that there are 2 reports which don't reflect the current position because they're outdated, and we understand that there is a 3rd report that was done with the mitigation in place. So it's outdated data which doesn't reflect the current position. What I'm going to suggest is that we're not in a position to discuss anything in relation to those documents today. What I'm going to ask through you, sir, is that a more detailed articulation of the case that's to be made based on those documents is submitted, preferably within 7 days, and then we'd ask for 7 days thereafter to put a response in writing by way of further procedures. So the sum total of all that is, yes, thanks for the documents. They've not been properly explained. There are other bits of information missing. I don't think we're in a position to discuss a week for the action group to put their points in more detail, and then a week for us to respond.
Mr. MacLeod for Carrick.
Thank you, sir. Yes, we're in exactly the same position as Mr. Hardy. We don't object to the admissibility of the documents, having now had a chance to consider them, but we don't have sufficient information at this stage to talk to the documents today. And I think that Mr. Hardy's suggestion is a very sensible one, and we would certainly endorse it from our point of view.
Mr. Fraser.
So I'm entirely in agreement with Mr. Hardy on the approach. If I might say, with respect to what we've been told so far, bullet points is putting it almost at its maximum. All we're told basically is it's going to be relevant to looking at things. So it's not possible for us to form any view at the moment. We do need to know what use, if any, we are being invited to make of these documents. I think the only on the instructions I've received, the only difference I'd have with Mr. Hardy is perhaps on the timescales that have been proposed. I'm a little concerned that our being able to respond to them when we don't really know what it is that we're being asked to respond to within 7 days may be unduly optimistic. And certainly the timescale I had in mind, sir, was to give the Safe Straighten for Scotland until the end of next week, which is just over a week, to put in writing whatever it is they're saying we should be doing with them. And then I think I'd have asked for 4 weeks for us to respond to them. That's the only difference I have. So.
There was an ulterior, I'm very grateful to Mr. Fraser. There was an ulterior reason for that timescale. That is that Mr. Mackay is going on holiday, as is always the way with these things. So I was trying to fit it in before he goes. If it isn't, and absolutely, I'm not objecting to more time being given, but Mr. Mackay would come back on the 26th of June. He wouldn't be able to look at it before then, and then he'd need a week or two after that. So that takes us into July. So if we're comfortable with that, then I'm happy to adopt Mr. Fraser's timescale. So it's either a week and a week, or if it's not that, then it's going to go into July to accommodate Mr. Mackay.
Thank you, Mr. Handy.
Mr. Hewson, to comment on what's been said, please.
I was just going to go to Ms. Traynor. Do you have any view, if you watched yesterday and you heard about the documents? You may or may not have them, but are the proposals put forward by the applicants essentially to give more time to consider them and provide written submissions? Do you have any objection to that?
I don't, but I missed that part of the presentation yesterday. My apologies for not attending yesterday.
Well, 2 documents were submitted. They weren't considered, but the applicants have had a sight of them now, and we've heard from the applicants how they would like them to be dealt with. Ms. Crossway, I think you were looking for Mr. Hewson to say something.
Yes, please. If Mr. Hewson would just like to make a comment, if he is happy with what has been suggested.
Yes, I'm happy with what's been suggested. However, the 2 reports, and I think you can't read one of them, they're almost identical. They're just 2 versions of the same report. So it's like a draft and then a second version. But the numbers that I will be referring to are fundamentally the same. And Mr. Hardy actually mentioned that he's aware of a 3rd report, which is after the 2 that have been submitted. If he could perhaps provide that, then that would expand the whole thing much and round it off, I would expect.
No, what I was saying was whether there is a 3rd report, because these are pre-mitigation. So my understanding is that mitigation was in place. It doesn't reflect the position. So I'm not putting that forward. I was assuming that there was.
Okay, perhaps Ms. Crossway can explain the request of the freedom of information that she asked for, and if it would have covered all of the reports that were available.
Yes, I can answer that. That these documents relate to a complaint that is a significant part of our report, and although the complaints are redacted, it becomes fairly obvious that this issue wasn't resolved, and I do not think there was a further report. And obviously we'll discuss these complaints in detail in the complaints section.
Thank you very much, Ms. Crossway. Now, based on what's been said, and given the late arrival of the documents, to ensure no prejudice to anyone, I'm going to suggest that we give all parties a really generous amount of time. I'm conscious there's a lot of procedures and sessions happening over the next few weeks that all parties are taking part in. So if we look for a backstop, probably about the middle of July to conclude this, we may allow 2 or 3 weeks for Save Straighten for Scotland to submit the documents and explain, and then again till the middle of July for the applicants, Ms. Traynor, to respond. I think that doesn't impact our timetable in terms of reporting, but I think it's just a bit more generous in terms of what we all have on, and I'm looking at you all there in terms of procedures over the next few weeks. So does that sound reasonable? What we would do is clarify it would be a formal further written submissions, which we'd normally give 14 days and 14 days anyway. But we'll look at dates and hopefully give you 3 weeks and 3 weeks, if that sounds reasonable. What that means, though, is that we won't delve into those documents today. For the applicants, happy with those timescales?
Yes. Thank you.
Fits in with everyone's holidays, Mr. Mackay? Good. Ms. Crosby, you happy with that, Mr. Hewson?
Yes, I just want to know, does this have a CD number?
No, because it's not actually been submitted yet. I think what I should have said is that there is no problem with them being admitted, if you like, submitted. So once they are, they will be given a CD number. And it will be up to, I suppose, yourselves or the applicants, whether or not in relation to your submissions or indeed the applicant's response, if they wish to submit further documents to support their view, which would be added to the core documents list as well. We'll cover all that in a procedure notice, so it's all clear that you don't need to rely on what I've said just now. That'll be written out in detail for you after this. So don't worry if you haven't taken notes. We'll get that done, and it will probably be issued towards the end of this week or beginning of next week. Okay, that deals with those documents. I think to the satisfaction of most, and certainly I'm content with that approach. If we can go back to the agenda, I think it was item 5D, and we were going through Mr. Hewson's hearing statement. Let's get a reference for that, just so you can have it to hand. It's CD 1705. That's what we were looking at yesterday. Okay, noise sensitive receptors, that's within the hearing statement. It's a section that deals largely with campsites. Now, I think we considered that in a discussion yesterday, and having read again Mr. Hewson's hearing statement at that section, I had considered that any questions I had been answered by the discussion yesterday, unless any party wants to discuss it any further today. But I think I had got out of our discussion yesterday what I was going to ask with regard to that section. Is that a fair reflection, Mr. Coulson?
Thank you, sir, and good morning. If I could just make one further comment, just one additional reference that I thought you may find useful, and that's in the IOA Good Practice Guide. That's CD 12.2, and it's paragraph 2.2.4 on page 7. It talks about background measurement locations and that they should be undertaken in the vicinity of noise-sensitive receptors. But it then goes on to provide some additional clarity as to what those receptors are, saying that they're principally houses existing or those for which planning consent is being sought or given, and any building used for long-term residential purposes, such as nursing homes. And I thought that was just hopefully a helpful piece of additional clarity.
Any additional matters from the applicants? I'm content to move on to item E then, unless Mr. Hewson has anything in particular, because we did have a discussion around the parties' views on that yesterday.
Yes, the only thing I'd like to comment on is Mr. Jiggins yesterday was sceptical about two comments that I made, one of which was that using a ground factor of 0 compared to 0.5 changes the predicted level by 4 decibels. And I mentioned that there were a number of papers that demonstrate that this is the case. I myself have calculated the same thing. And I have a paper here from 2004, which compares a number of models, and it compares ISO 9613 Part 2 using G equals 0 and G equals 0.5. And the predicted levels out to a range of 5 kilometers vary by 4 decibels, as I have said. So I hope that supports my comment in that regard for Mr. Jiggins. And secondly, Mr. Jiggins was sceptical about.
Just on that point, you've referred to a document which I assume we don't have and it isn't part of the core documentation. If you'd like to refer to that, given that we have got a further written submissions procedure that's going to be underway, and you wanted to submit additional comments with that document, then I'm happy with that. But I don't think it'll be reasonable for the applicants to comment on a document that they've not seen today. And I see Mr. Mackay and Mr. Jiggins' hand has gone up. Mr. Jiggins, you've got a 1 beside you, so you were first.
Yes, okay. I think if we're going to deal with it via further submissions, we can do that. I would just reiterate that my evidence of the inquiry is that I've looked at this matter for the residential receptors near to Knockcronal, and I've predicted the difference between them for the 2 factors that Mr. Huston suggested, and I get a difference of 2.1. So I'm suggesting that in the actual case of this wind farm, the difference is 2 dB, not 4 dB. Now, there may be papers that compare predictions for other scenarios, but for predictions for this wind farm, the difference is 2 dB.
And Mr. Mackay.
Thank you, sir. I would just like to add I've also undertaken predictions using both factors for this particular, for the proposed development for Craiginmoddie wind farm. I also found a difference of 2 dB at the closest receptors. I would note at larger distances, differences change slightly, but 2 dB at the closest receptors is what I'd found. What I would note as well is that I haven't seen the paper. I'm not aware of which one Mr. Huston's referring to, but I know he did say that it was undertaken in 2004. So I would also note that I presume, therefore, it didn't use the rest of the guidance included in the IOA GPG, which was dated 2013, in relation to the other factors which may well be material on the propagation of sound. So I know my model takes account of the requirements in the IOA GPG. I concur with Mr. Jiggins that results in a difference of around 2 dB, closest receptors. But it's not clear to me whether the same input parameters would have been used for that 2004 paper.
And I think it's going to be difficult to have a discussion if I haven't seen the document here. So I think what I'll do is I will capture that and allow Mr. Houston to submit the document, but allow the applicants to respond. So we don't probably need to discuss that further. You were going to make another point, I think, Mr. Houston.
Yes, all I was going to say was that it's right what Mr. Mackay says, that this was before the recommendations of the Good Practice Guide. And if you look at the Good Practice Guide, CD 12002, in section 439, the top of the page there, there's a correction whereby the concave situation requires a 3 dB correction, but if you use G equals 0, it says that only a 1.5 correction is used. So that might explain why Mr. Jiggins and Mr. Mackay have got different results. Rather than 4 dB, they might have got 2.5 or so. Just referring back to that section 4.3.9 of the Good Practice Guide, it's also confirmation that they acknowledge that you can use G equals 0. So it's not a thing that shouldn't be used in accordance with the GPG, which is policy.
Thank you, Mr. Houston. that didn't necessarily relate to paragraphs 59 to 64 of your or 65 of your hearing statement, but that's where we were with regard to item D, talking about campsites. But let's move on to E, which is the section on audible characteristics in accordance.
Could I just come back on that? That Mr. Hudson is repeating information that we've already covered yesterday about the use of G equals naught and what the good practice guide says, and that was rejected yesterday by the 3 applicants, and the good practice guide says that G equals 0.5 and 4 meters is recommended.
Yes, I've got that from yesterday, Mr. Jiggins said. If we can scroll down to, I think it's paragraph 93 of your hearing statement. In relation to paragraphs 93 and 94, I think we've probably discussed this yesterday again, but Mr. Houston, do you want to make any comment and allow the applicants to come back on that, or were you content that we discussed that yesterday? That's in relation to tones.
Yes, only that it was mentioned yesterday that in my experience, many wind turbines do emit tones. They have been measured, and there are quite a few large wind turbines over here in Victoria in Australia that I've measured and others have measured, and they have demonstrated tones despite the promise from the developers and the wind turbine manufacturers that they would not emit tones. So all I'm suggesting is that in the absence of any test results demonstrating that these particular candidate turbines don't emit tones, then it might be appropriate to add a penalty to predicted noise levels.
And as I recall from yesterday's discussions, the applicant responded to Mr. Jiggins. Would you like to respond?
It was only to reiterate what we went through yesterday, which was we covered this point by saying that the good practice guide recognises that test reports proving for a particular turbine won't necessarily be available. That's quite clear. And that our experience is not consistent with Mr. Hudson, and that turbines don't always have tones, and therefore to add penalties arbitrarily for the inclusion of tones would be disproportionate, we feel.
And that, from memory, that reiterates the comments that were made yesterday. I don't see the hands of the other applicants up, so I can move on to the next part that had some questions, which is item A, which is on noise predictions. And it may be the case that we covered most of that yesterday. Is there any elements of Mr. Houston's hearing statement? If we go from paragraph 124 to 136, which is noise predictions, over and above what we discussed yesterday, is there any particular element of these paragraphs that the applicants would wish to respond to? We've had a discussion just a second ago about some of it in terms of the G value. Ms. Crosby, you've got your hand up.
Yes, Mr. Houston's references to infrasound and low frequency sound and vibration at paragraph 66. I think Mr. Houston maybe should cover that, because that is part of his evidence as well.
That is the case, but I think we discussed that in our earlier sessions yesterday, so I don't have any further questions. I think I'm quite clear on the parties' positions and their different positions on those matters, and I don't have any further questions. I think we covered that in our early session with regard to how I should treat these matters. So I don't have any particular questions to ask. I've got the different views of the parties, and I don't think it's necessary to ask additional questions beyond the discussion that we had yesterday, unless there is a particular point that Mr. Hewson wishes the applicants to respond to. But I think the applicants have made their position fairly clear. And if I could complete item 5 of the agenda, and perhaps once we come to the summary of opinions, item 8.
Excuse me, sir, just before you move on, could Mr.
Sorry, we would like an opportunity for Mr. Hewson to talk to his report from paragraph 66 onwards. I know you say we discussed it yesterday, but Mr. Hewson didn't have an opportunity to refer back to his report, and it's important in our view that Mr. Hewson does speak to his report, because this is what this section is about.
Oh, I was just, before you interrupted, I was just about to say that in item H, we have a section called Summary of Opinions. And at that point, I'll ask Mr. Hewson to highlight matters in the sections that we haven't discussed that he wished, and the applicants will have an opportunity to respond. And that I think will deal with that matter. But I don't have any specific questions with regard to the sections of my own. So was there anything from section 124 onwards to 136 that the applicants wish to comment any further on? Scoresby, you still got your hand up? That's good. There's nothing additional there. Is there any particular point within that section on noise prediction, Mr. Hewson, that you would like to flag up to ourselves, being of importance that we haven't discussed already?
No, only that the summary of those items will be discussed in the summary of opinions that we're going on to next.
Item G now, which is wind speed data. And again, when I read over this, I seem to think that we'd covered most of these matters off yesterday, but I would like to give both Mr. Hewson and the applicants an opportunity to flag anything and have a discussion around any points from paragraphs 139 to 145. From the applicant's point of view, is there anything over and above what was said yesterday that you would like to respond to in the wind speed data section of Mr. Hewson's hearing statement? Yeah, for Carrick.
Thank you. Yeah, I just wanted to pick up on a point that's made in paragraph sorry, sir, in paragraph 143 of this Mr. Hewson's statement, which repeats points made also in paragraph 52, which we discussed yesterday under item item C. I just wanted to correct a statement that was made by Mr. Hewson yesterday. Mr. Hewson stated that the use of SODAR or LiDAR systems in measuring wind speed data is the least preferred option in the IOA Good Practice Guide. So if I can just take you to CD 12.2, which is the GPG, in paragraph 2.6.3 on page 10 of that document, there are 3 methods of wind speed measurement that are outlined. Option A is direct measurements at hub height, and there are 2 sub-options within that method. One is using a MET mast, and the other is using SODAR or LiDAR systems. And then method B is using a MET mast at a lower height, and then method C is using a MET mast at a height of 10 meters. If I take you through paragraph 2.6.4, which provides just an illustration of those three methods, and then paragraph 2.6.5, which states very clearly that methods A or B are preferred. And just to take you back to 2.6.3, method A includes the use of SODAR or LiDAR systems. So it's very clear from the GPG that the use of SODAR or LiDAR is not the least preferred option, as Mr. Hewson suggested that it was. It's actually one of the preferred options. Just wanted to correct the record on that.
Thank you, and I've got all these references. Mr. Hewson, would you like to respond?
Yes, the reference in the practice notes, one of the good practice guide notes actually says that if you're going to use SODAR and LiDAR, then you ought to be using a qualified person to do it. Mr. Jiggins explained that that was the case in this situation and assured me that the accuracy was also accommodated such that it would meet the ETSU requirements. So I'm happy that the LiDAR and SODAR measurements have complied with ETSU. So my question in 143 was really a question of the accuracy, and that has been assured by Mr. Jiggins yesterday.
Thank you. Mr. Jiggins?
Yes, I was just going to confirm that that was what we agreed yesterday. And so I think the word suspect in 143 is probably an incorrect word to use. It was more of a question. Suspect that it may not have been, but I've confirmed that it is. And that's where we got to yesterday.
Any other points in that section on the wind speed data? I didn't have any further questions there. So now we come to the summary, and at this point, just go to the summary of opinions. As Ms. Crosby highlighted, there are elements of the report that I hadn't asked questions on because we had a wider discussion on those yesterday. But I'll invite Mr. Hewson to highlight points that we haven't discussed that you'd like to bring to our attention, perhaps one by one, and then we'll have a discussion on those matters. I think Ms. Crosby was keen that you did that, so we'll allow that now. Mr. Hewson.
Yes, so would you like me to go through the 146 through the different paragraphs one by one?
You don't need to go through them one by one, but if you could highlight elements that you don't think have been discussed fully and you want to bring to our attention so that we can have a discussion today. If there, you don't need to go through each one because we've discussed quite a number of them. But if there's elements in your summary that you wish a discussion on, then I'm happy to have that today.
Might be better if I do go through them one by one, but very, very briefly. So 146, I'm just suggesting that the 3 wind farms have zero margin of compliance with the suggested targets. So any variation on noise modelling or target limits of noise would demonstrate non-compliance. So that's one issue that we've covered. The margin of compliance at noise sensitive receivers. If consideration of special, I've used the term SAC, that's not the South Ayrshire Council, that's special audible characteristics. I'm sorry if there's a misunderstanding there. All I'm saying is that if the actual turbines that are built do have tonality or any other acoustic characteristics such as amplitude modulation, then obviously that would lead to a non-compliance automatically. My issue with regards to using manufacturers' data, we've already covered, and I'm suggesting that IEC 61400 Part 11 doesn't actually account for site effects. So if the manufacturer are using that methodology to assess the sound power, I've attached in the appendix a reference by Mr. Eric Sloth, and he is one of the key researchers in the dual study that's referred to in the Good Practice Guide. And he also recommends that site effects can increase sound power levels over and above those that you might find from manufacturers' data or test data even. We've covered the margin of uncertainty required in the GPG, and that's been covered and addressed correctly. Thank you very much yesterday. The wind speed details we've also covered yesterday with regards to the use of LiDAR and SODAR. The only issue that remains is that it's questionable whether the correction methodology that was used for transferring met-mast data from Adyard Hill over to the adjoining proposed wind farm actually meets the accuracy requirements of GPG. And I don't think we've addressed that at all. I don't think that has been addressed correctly yet. And again, 151 is what we've just discovered about LiDAR and SODAR. And I accept that the accuracy is, as Mr. Jiggins has assured. 152 refers to camping and caravanning sites. The issue that I have with those I've detailed in my submission. So basically my proposition is that a lower target should be used for those because there's little attenuation outside to inside a tent. And that all camping and caravanning sites ought to be included in an assessment by these applicants. 153 also just refers to that and goes on to suggest that to protect the sleep of occupants in accordance with the World Health Organization's recommendations, which are the fundamental of ETSU, that a target noise limit for a campsite would be 30 dBA LEQ. And 154, low frequency sound isn't considered separately in ETSU R97. This is the section that I've discussed in the statement earlier. One of the reasons for that is that ETSU was derived using very small wind turbines back in 1996. And the scale of these larger ones have the propensity to produce low frequency noise in excess of those from the era of 1997. So to protect occupants of dwellings from low frequency noise that may exist, they may not, but there's a possibility. I'm suggesting that the DEFRA NAN R45 standard be included as a condition just to cover the eventuality. Regarding infrasound in paragraph 155, I believe that it still remains an area of contention, and it's not proven one way or the other whether there is an adverse health effect. The two sides of the argument put forward their case quite vigorously, but I don't think it's decided yet. But in the absence of future research which is ongoing, it may be appropriate to include some form of condition that puts an infrasound criterion back in if it's been decided by governments that may be appropriate to protect health. Paragraph 156, excess amplitude modulation. I've investigated these issues with amplitude modulation quite extensively. And the fundamental of ETSU is that you assess the variation in sound level as a dBA value, between the peak value, the higher level. Generally, if you can imagine the swish of a turbine, when the swish occurs, it produces a higher level, and then between the next swish, it's quiet, and then it goes to the next swish. The difference between the highest and lowest value of the dBA value is the amplitude modulation. So that's the variation in sound level caused by the swish of the blades. I'm suggesting that if the wind farms are permitted, that there should be an appropriate limit for amplitude modulation included. And I'm suggesting that the well-tested condition 20 from the Denbrook wind farm that went all the way up through to the High Court in the UK would be appropriate. There have been suggestions that other wind farms in Scotland have had different conditions regarding amplitude modulation applied, but I don't think any of them have been tested in any court. So my preference would be one that has been tested in court, and that's why I refer to condition 20 of the Denbrook wind farm. Paragraph 157, we've covered this at length now, and I'm simply suggesting that a cautious approach should be used, especially in light that ETSU itself may be under review shortly. But even though we're constrained to use ETSU, then at least err on the side of caution and produce robust predictions. And to do that, I'm suggesting, again, G equals 0 with a receiver height of 1.5 meters. Paragraph 158 we addressed yesterday, and that's already been addressed by the applicant in that regard, so that's not an issue. 159, all I'm considering is that if you allow the higher target noise limits for camping areas, that might adversely affect tourism in the area. But again, that's just a possibility, and that can only be tested if the actual campsites are predicted by proper modelling by the applicants. Paragraph 160, in response or in respect of infrasound levels, if in the future they're deemed to be an important health effect, and research demonstrates that that is the case, you have a situation where if you don't assess a baseline of infrasound now before wind turbines are constructed, then you won't have the opportunity of effectively a background baseline infrasound level against which to comply in the future. So I'm suggesting that it would be wise to collect samples of infrasound in the area as a precaution should there be future requirements for limits on health effects from wind farms with regards to infrasound. In paragraph 161, I have measured many turbines, and they do emit tonal sounds. There are very few that don't emit a tonal sound in my experience. And the tonal sounds often can be heard in the lower frequency register. And I've mentioned in my hearing statement that I've measured the Cape Bridgewater wind farm, and the nearby residents are exposed to a 32 hertz tone, which is modulated by the blade pass frequency. And that is actually quite annoying when you listen to it on headphones. So the issue of tonality from wind farms is an issue that I think is contentious. I believe that tones are readily emitted by certain wind turbines, and that's why I'm hoping that the developer would have provided test results from their candidate turbines rather than just manufacturers' predictions. And paragraph 162, with regards to the recommendation for DEFRA NAN R45, when I mentioned about this 32 hertz tone that came from the Cape Bridgewater wind farms, when you observe the tones inside dwellings, 32 hertz can correspond to a room resonance. So the effect indoors is actually amplified. So the tone from a measurement outdoors of this particular 32 hertz tone that's modulating is amplified depending on the room size within dwellings. And to address that potential, that is a real potential to occur, that's a further reason for using DEFRA NAN R45 as a condition to assess low frequency noise, because that is measured indoors. And finally, with paragraph 163, in consideration that the predictions are showing zero margin of compliance with the issues that I've raised, I don't believe that currently the project should be granted in its current form. No doubt if the layout and number of turbines were adjusted and models repeated, that could address and meet the 35 dB target that I'm proposing should be used, and that also South Ayrshire Council proposed should be used. And there's no doubt that you should be able to meet a 35 dB target with a redesigned set of turbine layouts.
Just for clarity, before I open it up to the applicants to respond to any of these matters, your view is that for the reasons you've set out, all three applications should not be granted approval. Do you consider them individually with regard to your views, or is that each one individually? Is that your view, and collectively, cumulatively, I suppose is the better term?
Well, individually, each of the developments have been modelled, in my view, incorrectly. They've been modelled optimistically. Mr. Jiggins explained that he did a calculation and had a 2.3 dB increase, I think, with the different input parameters to the model. A 2.3 dB increase would obviously take you above a zero margin of compliance. So there's one situation, and I think James Mackay also suggested that he would experience an increase as well with the changed input parameters. And again, with a zero margin of compliance, then that's another wind farm that would most probably not comply.
So you clarified that it's not just cumulatively, it's individually. So that's useful. There's a lot of points there to respond to, but I just thought I would let Mr. Houston roll through his comments, some of which we have discussed already. But Mr. Mackay, I think you're first to go this time. No need to cover points that have been covered up before. I know that you've covered all applicants have covered some of those subjects, if not all, in your hearing statements. So we have that. But was there any particular points that you wanted to respond to? And then we'll ask the other applicants. Mr. Mackay.
Thank you, sir. Yes, you're quite right that we've covered most of these things in detail previously, and I am loath to repeat the responses to each of them individually, but there are a couple I'd like to flag, if I may. Just in relation to the wind speed point, appreciate Mr. Husson doesn't agree, but I did want to reiterate my points from yesterday that the mast used for the Craiginmoddie wind farm assessment does comply with the accuracy requirements as set out in the GPG, and the adjustment to account for the difference in the site locations was undertaken as required by the GPG as well. Specifically in relation to conditions, I appreciate we have a section on that later on, so I don't propose to respond to the suggestion of conditions at this stage, although I'm sure we'll discuss it. I would, however, like to flag that, whilst I disagree with Mr. Husson's point that regarding predictions, I do think they're reliable and robust. They do concur with my general experience of undertaking noise compliance monitoring. I would flag that as a worst case, and to be clear, I don't believe this is going to be the case, but if predicted noise levels from proposed developments are for any reason higher than predicted, the planning conditions that are proposed would provide appropriate protection to residents. Noise limits have been proposed and allocated and spread out, between the 3 proposed developments as discussed yesterday. And in the event that noise levels were higher, those conditions would provide suitable control, and the operators of any scheme would have to ensure that those conditions are met. So I personally do not think it's that constitutes a reason for refusal, individually or collectively.
Mr. Mackay, Mr. Poulsen or Mr. Jiggins? Mr. Poulsen.
Thank you. Yes, just to concur with Mr. Mackay's point there about the condition limits providing appropriate protection to the local residents, but also just to pick up on a couple of points raised in that rundown of the different paragraphs. I don't intend to repeat points with regards to temporary receptors and LiDAR and SODAR, etc., that we've already discussed. One point which I thought was of value is with regards to paragraph 146, it says that the 3 wind farms have a 0 margin of compliance. And I think Mr. Husson also referred to that again with respect to paragraph 163. The margin of compliance is, of course, dependent upon which receptor you look at, its location, and what wind speed the site is subject to, which has an effect on the measured noise levels and the background noise levels. So it is a complex situation. It's simply not the case that there is a 0 margin of compliance at every receptor for every wind speed. And I think a useful thing to look at would be within the SOAM in Annex G. So the SOAM is CD reference 1514 in Annex G, and then tables 21 to 26 present the margins of compliance at all receptors for each different wind farm based on their site-specific noise limits that have been determined. And if you look at those tables, you'll see there are many, many receptors where there are significant margins of compliance, and it's certainly not the case that it's a 0 dB compliance at every receptor.
Thank you, Mr. Poulsen. Mr. Jiggins, do you have anything to add?
So there was another couple of points. Do you want me to come back to those later?
Sorry.
No, that's fine. Just wanted to say also with respect to paragraph 154, Mr. Husson identified that low frequency noise isn't a material consideration for 2R97, and I concur with that. And I would like to just pass over to my colleague, Mr. Lettinger, if that's okay, to talk about the suitability of the NANR 45 assessment method in terms of condition.
Thank you. Yes. So firstly, just to not repeat the points made in our hearing statement, but if I can just draw your attention to pages 20 to 23 of our statement CD 1227, we talk about some of the evidence there that indicates perception of wind turbine sound. It's not necessary to impose additional controls on low frequency sound in the way that Mr. Husson's proposing. And in relation to the NANR 45 guidance, now, unfortunately, I think that this hasn't been submitted as a core document, so I can't go into any detail on that, but I would just say that the scope of that guidance is very clear, that it's intended to be a nuisance investigation tool, and it has not been designed as a planning or predictive tool. And the criteria that are defined in that guidance are intended to be indicators of when an existing low frequency noise disturbance that is subject to an investigation may indeed be causing a disturbance. And the guidance also clear that levels above the criteria curve, which is contained in that document, are not necessarily unacceptable.
I think just on that point, if anyone has objection, I think we will, through the further written submissions, just request that document so that I can double check those references. Hopefully all the parties are happy with that.
So if I could just continue one moment more. So also another document that's referred to in Mr. Hewson's statement in paragraph 118, which is another DEFRA report known as NANR 277. I think it's stated as 277 here, but it may be 227. Forgive me, I'm not sure. But in paragraph 118 of Mr. Hewson's statement, he talks about this other DEFRA report, which outlines a procedure for investigating statutory nuisance or potential statutory nuisance complaints in relation to wind farm noise. And in that document, which I apologise is also not before us as a core document, that document refers to the NANR 45 guidance as being an appropriate methodology for investigating low frequency noise complaints as a potential nuisance issue. But it's not anywhere recommended as a tool for planning stage controls.
I think we will request those two documents just for completeness. I do know that one of my colleagues, Mrs. Leven, has her hand up. Mrs. Leven.
Thank you. It was just a similar point about the core documents list, and it was to do with paragraph 156. I think, Mr. Hewson, you refer to the Denbrook Wind Farm, and I think you've included the wording of that condition, but I'm not sure you've included the whole decision in the core documents list, which I think would be useful. So again, we could ask for that if it's not already there.
Everyone seems to be agreeable to that. So in the further written submissions, notice that you'll always see we will refer to those, and we'll pick on the party we think is most appropriate to submit these documents. We've heard your views on them, so we won't necessarily be inviting comment on them. It's just so that we can double check what references have been provided. Mr. Jiggins, were you wanting to make any additional comments?
Yes, if I can, please. I would reiterate what Mr. Mackay said about effects of the site. Mr. Huston's said that site effects can give rise to higher sound power levels, and that predictions are not pessimistic enough, and that we need to add penalties for tones, and that we should, when incorporating all of those pessimisms, which are all extremely unlikely, actually, to all add up together. But it seems to me that the consequence of adding all those pessimisms in is that you wouldn't have any wind farms at all, because the levels of decibel reductions required to take account of all the things that Mr. Huston said are so large as to preclude wind turbines entirely. So I think we have to balance Mr. Huston's views against what's reasonable. And it would not be reasonable, I think, to take all those pessimisms and use that as a reason to never have any wind turbines again, which would be the consequence. So I don't accept Mr. Huston's suggestion that it's possible to take all those things into account and meet the 35 dB cumulative limit with a site redesign simply. I think that's entirely misrepresenting what could be achieved, and I would suggest to yourselves that it would actually result in no wind turbines. So that's a general point, really. To reiterate what Mr. Mackay said, that any of these uncertainties, if they do arise, they can be tested. The conditions proposed would allow for testing of compliance on receipt of a complaint, and that is a standard ETSO R97 approach. Mr. Huston then also said that because ETSO R97 is going to be reviewed, that would mean that we should really be taking a pessimistic view on predictions. Well, I would just draw your attention to the fact that ETS 197 does not include a prediction methodology, and the prediction methodology is set out in the Good Practice Guide, which is 2013, significantly later than the ETS 197. Some of the other things that have been touched on, NANR 45, again, I see significant difficulties with NANR 45 being a criteria to be applied. Whilst it might be useful for a complaints investigation, we are talking about measurements being done indoors. And if I can draw your attention to CD 12001 ETS 197 on PDF page 63, which is internal page 45, where it considers whether noise limits should be set internally or externally. There's a discussion there of the practical difficulties of undertaking internal noise measurements and the imposition on people who complain about noise having to house equipment indoors in order to do that. And I think that's a significant practical limitation of indoor measurements. So I would raise that as well as a reason for not doing that. Mr. Hudson talked about infrasound being a contentious issue and suggests that baseline should be gathered on a speculative basis, that should it subsequently become something recognised as a problem, then we should preempt that, imply conditions to preclude it, and do baseline surveys of it. I think that that's entirely unreasonable, given that there's no evidence that those things are of any importance at the moment. And to do so would be unreasonable, in my view. In terms of tones, I think we've gone through that issue with regard to turbine information a number of times now. And the potential for turbines to emit tones is included in the ETS 197 assessment methodology and get penalised as far as compliance assessment goes. And therefore, that's the appropriate mechanism by which tones are controlled. And those are the items I wanted to raise. Thank you.
Well, I think that takes us through Mr. Houston's hearing statement, which I think Ms. Crosthwaite had indicated that's their main evidence with regard to ETSU framework. And our discussion yesterday and today, I've given that a fair hearing. I've got a couple of questions myself on each of the applications. That's item 6, 7 and 8. I propose that we break just now. We'll have those, and then we'll have another short break to allow Ms. Traynor to be prepared. Ms. Traynor, before I go through my items 6, 7 and 8, at the end of that item, I will ask the applicants to have your submissions to hand. So if you've got the core document reference numbers to hand, that would be good. If not, I think I have them here. But we want to leave the applicants for that short break to know which documents you might be referring to, Ms. Traynor. So once I've completed 6, 7 and 8, we'll have a short break. And at that point, before that break, if you can just list your core documents or refer to the submissions that you've made. And it may well be it's your main submission on Craiginmoddie. So, but that still doesn't change the fact that I said we'd have a break just now because we've been going for an hour. So I would propose that we break until 20 past, just a 10-minute break, a 10-minute comfort break, and then we'll come back and do 6, 7 and 8. Is that all quite clear? Excellent. Okay, we'll see you in 10 minutes. Okay, I think everyone seems to be back. Mr. Reid, do you have your hand up?
Yes, thank you, Mr. Bray. I just wonder whether when people are referring to the core documents, if they could just give us a bit more time. So when they're referring to them, just a bit more slowly so we can actually take note of the actual core document reference number, because sometimes it's kind of scooting through and then onto a page and para number before we've got the actual note of that. So if people could just give a very slight pause or just say it a bit more slowly, just so that we can all make sure we've got the right reference down, that would be much appreciated. Thank you all.
Thank you very much, Mr. Reid. So we're on to items 6, 7 and 8, and these are just some questions that we have. As I said yesterday, I think the CD references on the agenda were one out of step. So in terms of Craiginmoddie, is 1226. And we know that the Craiginmoddie assessment was updated, if you like, by the additional information and the T&E report of March, and that's fed into the statement of agreed matters. But in terms of, you're quite clear that I think it was stated yesterday, and it's in the documentation, that the site-specific noise limits that are slightly different in the statement of agreement of Craiginmoddie, it's those in the statement of agreement that would apply if there was a scenario where Craiginmoddie was to be consented on its own. I just want to be clear on that it's the site-specific noise limits that were agreed through the schedule, the statement of agreement. I think I heard that yesterday, and I think it's in your statement, but I just wanted to make sure that's the case. Mr. Mackay.
Thank you, sir. Yes, that's quite right. Whilst the assessment that we undertook did present site-specific noise limits, those are effectively superseded by the ones in the statement of agreed matters, which is CD 1504, 014. Yes, and I'm content that they're appropriate. The main reasons for the differences, as I think we discussed yesterday, is we've taken a slightly more conservative approach in that assessment. The T&EI assessment relied on our predicted levels. In some cases, as Mr. Jiggins explained yesterday, when we were undertaking the work to inform the statement of agreed matters, we used the worst case predictions from our 3 assessments. So that's why there's a difference. The other difference relates to how the noise limit was apportioned Doughty Farm. And again, that was agreed between myself, Mr. Paulson and Mr. Jiggins. So yes, the limits in the SOAM are the ones that I agree with and would propose.
So the potential or the requirement for mitigation that may be required for Craiginmoddie is the same on an individual basis as it would be on a cumulative basis.
That's correct. Yes, it is.
Verify that. You've prepared quite a number of responses to the third parties all the applicants have, and that actually covers quite a lot of ground that we've discussed over the hearing so far. I don't have any additional questions there. We are going to go on to discuss Strainer's concerns as a separate item, Mr. Mackay, and I'm sure there'll be questions for you there. But unless Safe Straighten for Scotland have got a burning question for Mr. Mackay with regard to either the hearing statement or anything else that they haven't had the opportunity to discuss, I would just move on to Carrick. But Mr. Houston or Ms. Crossway, is there anything that you haven't covered that you would want to raise with regard to the hearing statement of Craiginmoddie?
You do it.
I think we just wanted to draw attention to the fact that the applicant for Craiginmoddie was involved in the authorship of the IOAGP. We'll comment on the other applicants as we come forward. But I mean, that's a point of note for the public and the residents listening in, that we've got parties involved in this inquiry. All of the parties involved in this inquiry, all of the acousticians, have had extensive experience and involvement with the current ETSU guidance at various stages, from the inception right the way through to the various the IOGP guidance notes that come through. So the suggestion is that it's not just about compliance, it's also about protecting perhaps their own positions.
Well, certainly there have been a number of submissions made which address I would say credibility matters, which are more difficult to consider in an inquiry situation. We're dealing with what we consider to be the relevant bits of evidence. All the parties have generally steered away from the credibility arguments, which has been really useful, I think, in our discussion over the next day. But I take your point, and it is noted, and certainly it has been made by parties across the submissions so far. In terms of Carrick hearing statement, that's 1227. I may have missed it, but are you quite clear in terms of a planning condition for amplitude modulation that on your position? You reference the fact that there's still ongoing discussions with the council, but is your position quite clear that that's not or is required?
Yes, sir. Our position is that an EM condition is not required. I think either Mr. Jiggins or Mr. Mackay actually made some submissions on the appropriateness of an EM condition earlier on, and we would endorse that. So certainly our position is none required.
Thank you, Mr. Cloud, for clarifying that, and we'll come on to discuss planning conditions later on. And again, that was actually the only point that I think hadn't been covered in the hearing to date. But I would ask Safe Straight for Scotland, was there anything particular over and above what we've discussed that was contained in the Carrick hearing statement that you wish to bring to our attention?
We actually have a number of things that we'd like to talk about with the Carrick hearing statement. I think I would like to start with a question from Mr. Latinga with regard to paragraph 89, where he says, "My point here is not to completely discount the possibility that larger turbines may emit greater lower frequency sound energy than smaller turbines, but to highlight that this notion is not proven knowledge, but rather is an open matter of scientific debate." Mr. Latinga, as a noise and vibration engineer with 15 years experience, I find your point at paragraph 89 implausible. Why have investigations with real people suffering from genuine physical health problems when continuously living close to wind turbine developments, where you have given evidence that they are safe to operate, not being investigated by the wind industry? The scientific evidence is out there, including in the IRO report, which you comment on. It seems to me that all the studies referred to in your report are controlled experiments and not dose responsive. They're not studies on actual people who are suffering after exposure. They do not include site-specific examples, which include topographical impact or cumulative impact from different directions meeting in the location of someone's home.
Carrick, to respond to that?
Yeah, sure. Happy to respond on that. So on paragraph 89 of our hearing statement, I'm concluding a point made in the preceding paragraph 88, which is which covers some evidence that was reviewed as part of our report for Bays, which is called document 1215. And in paragraph 88 of our statement, I'm quoting from the report. And so, sorry, to take a step back, there are two points made here by Mr. Crossley. One is about low frequency sound emissions from the site, depending on the size of turbines. And the other one is about health effects. So firstly, I'll address the issue of the size of the turbines, and then I'll go on to address the issue of the health effects. So the first point being, in paragraph 88, we discussed evidence about the commonly held notion that larger turbines emit greater proportions of low frequency sound energy. And we noted in that review that there was a study undertaken for the Danish government which systematically investigated the effect of turbine size on the spectrum, whether or not there was increased low frequency sound emissions in the spectrum. And there were differing conclusions that came from that study. And eventually, after further analysis of a larger data set, it was concluded by another member of the consortium that there was no systematic increase in low frequency sound associated with larger turbines. So the point made in paragraph 89 is really just a conclusion to highlight that it's a popular notion, but it's not one that seems to be supported by consistent evidence. So that's the low frequency side of Ms. Crosthwaite's question. The other part of it is about health effects. So if I can draw your attention to paragraphs 81 to 87 of our hearing statement. So are covering quite a lot of evidence there that was also again presented as part of the study done for the Bays report. And a lot of that evidence systematically investigated exposing people to infrasonic signals from which were modeled to be similar to wind turbine infrasound. And virtually all of the evidence I presented in our statement is quite consistent in showing that physiological and psychological health effects are not caused or are not a result of exposure to wind turbine infrasound when it's experienced at the levels that are typical for wind farm neighbours. And so from our conclusion from that is that at the moment the weight of evidence doesn't support the notion that health effects are caused by exposure to wind turbine infrasound. I'm not sure. The point that Ms. Crosthwaite seems to be making is that there's other evidence that should be taken into account. Now, we've considered some of that evidence that she's mentioned about the IRO, the International Acoustics Research Organisation evidence that's been submitted to this hearing. And we've reviewed that evidence, and our review suggests that it's scientifically weak, and it doesn't present any convincing evidence that the effects that are observed in that investigation are actually causally related to wind turbine infrasound. And I won't go through all of the material that I've presented in the statement. It's there to be read. But all of the evidence that Ms. Crosthwaite's talking about is usually case study evidence based on a very, very small number of participants, and it conflicts with the weight of evidence where scientific controls are placed on the exposure and response, such that we can actually make more robust conclusions from the evidence that's taken from controlled experiments. I hope that answers the question.
Thank you. Mr. Crosby, I think you said you had other matters you wanted to raise, but perhaps I could bring in Mr. Hewson now, because he might want to respond to those particular points before you, Ms. Crosby. Mr. Hewson.
Just with reference to the double-blind randomized crossover study in noise-sensitive health in adults that was referred to, which is the 72-hour simulated test that has just been referenced. Presumably you're aware, as I've stated in my my submission, that the conclusion is that the study suggests that the infrasound component of wind turbine noise is unlikely to be a cause of ill health or sleep disruption, although this observation should be independently replicated. So in actual fact, the question's out on that particular study, and also that same study admits in the body of the paper that they were not able to generate infrasound from the fundamental of the blade pass frequency in their tests. So not only did they not actually have actual wind farm noise that was exposed to these people in the 72-hour simulations, they failed to actually simulate properly the blade pass frequency components, and they couldn't generate the fundamentals. And furthermore, it was constant sound that they were playing, not varying sound, which is typical of real wind farms. So I take the paper that was referenced with a pinch of salt, and still believe that the question is still unresolved regarding infrasound and the effects on health.
So that's your point. The main point is that it's an unresolved matter. I think you wanted to come back on that.
Yeah, if I may, I just wanted to say, I mean, it's a long-standing joke amongst engineers that any research report concludes that further research is needed, and the study that Mr. Hewson's referring to is probably, I would say, the most comprehensive and carefully controlled study of physiological and psychological health effects from wind turbine infrasound that's so far been published. And the researchers, who I would point out are from well-respected research institutes and experts in the field of health, report and I'm quoting from our statement here, a high level of confidence that an appropriate wind infrasound exposure was generated in the study.
Okay, thank you. I've got that. Crosby.
Yes, at this point, I would really like to ask you, sir, if Rita Holmes could please state what she actually experienced living close to two of these large turbines. We're talking about 35, I think, of these turbines now that turbine 10's been taken away, going to be close to about 185 homes within the area, the whole area, and for the benefit of all those who are watching and listening who haven't had the benefit of reading our report, I think it's really important that she describes what it feels like to live in the shadow of these turbines, and it's not just the audible noise, it's what she knew when the turbines were on and off and she couldn't see them. And I would really like the opportunity for her to speak to everybody if it's possible.
It doesn't directly relate to the Carrick hearing statement. I take it Ms. Holmes is on the call today.
I think she's on the call.
just not seeing.
Okay.
So I think
well, if I could possibly, it directly relates to Knockcronal hearing statement. It directly relates to one of them, and I think it's Knockcronal actually. So we can bring it up at Knockcronal if that's okay with you.
And certainly, if you want to refer to any of the core documents that have been submitted with regard to Ms. Holmes' evidence, then make references to it. Then, if it's not possible to hear from her just now, and we can move on to Knockcronal just now.
I have things I'd like to raise, if that's all right.
In terms of Carrick, yeah.
I'd like to just go with Carrick. Yeah, is that okay for me to carry on?
Yeah.
I'd like to refer to. I'd just like to go back to what we were saying about the size of the blade. Henrik Moller and Christian Sedger Pedersen, they have a paper that actually states that there is proof out there that the larger blades give off more infrasound.
And do we have that paper?
I have that one in. I'm not sure. I can make sure I submit it with the next. It's a very short piece, just an abstract.
So you don't think it's part of the core documents?
It's in the reference of the Carrick documents.
Yeah, all right, okay, right, okay.
Okay. And yes, it's one of the Mr. Latinga's references, I think. And could I just ask Professor Alves Pereira to speak about the Carrick document as well, because there's a lot in there about the criticism of the chapter, saying that it has a lot of bias. Again, we have a lot of bias on both sides of this and conflict of interest within ETSU, because so many people who are involved in these applications are involved in.
Sorry to cut across, but I'm really not keen that we get into matters of credibility and whatever. I think I will stop participants if they deal with that matter. I'm really interested in just discussing the evidence rather than accusations of bias, really. So I would ask that you stay away from that. That point's been made in your statements. I think actually Mr. Latinga has had his hand up to respond for some time now. So would you like to come in?
Yeah. Thank you. Yeah, just to pick up on the reference made there by Ms. Crosthwaite to a particular article. Yes, she's correct. It's cited in our statement in paragraph 88, and it goes to the issue that I mentioned about conflicting results from analysis of the same data set undertaken for the Danish government. So Ms. Crosthwaite's highlighting results that are presented by Moller and Pedersen. Conflicting results were presented by another partner on the project, having analysed the same data set. So the point being made, obviously, as I've already said, is that it's not proven knowledge, but is an open matter of scientific debate. So different opinions from different researchers analysing the same data set.
Okay, thank you. I would really like Professor Marianne Alves Pereira to come in at this point. She had become disconnected, but I know that she's back in because Mr. Latinga has quite a lot to say on the chapter. And again, he uses the term bias, not me. And I think that if Professor Alves Pereira could come in at this point.
What I'm going to do is I'm going to bring in Mr. Hardy at this point, because I think he's had his hand up and wishes to make a point.
Okay.
Mr. Hardy?
So yes, thank you. I'm very pleased that you made the comment about character. But I think it is just worth reiterating the word bias has been bandied around a few times. And I mean, that's a matter of considerable regret. I know you've got the point. But if the suggestion is being made by reason of involvement in documents, that self-interest results in bias, which effectively means that there isn't straight objective evidence being given. That's quite a weighty accusation that's being made against members of a professional organisation. So I know you're trying to police that and say that character shouldn't take part, but I'm just, concerned that what's being put against my witness, who's a member of the professional acousticians body, it's been suggested that somehow he might not be giving straight objective evidence in a professional capacity. So it's a serious matter. I'll leave it there, but I just wanted to register that point.
Thank you, Mr. Hardy. I'm sure all the parties have taken what I've said and the point that you've made. At this point, Alice Pereira, do you have any questions rather than observations? Really, it's questions on the Carrick hearing statement that you would like to ask through me.
Well, I would like to ask what is the significance for the author of the Carrick document? What is the significance for putting on figure 1, if you go to paragraph 70 on the Carrick document, page 15?
Yeah,
so what for the author is significant about putting these perception lines near the wind turbine acoustic pulse on top of the wind turbine? What was the objective here to be shown?
Are we able to provide an answer to that question?
Yep, happy to clarify. The explanation is given in the text in paragraphs 68 to 70, and there are two purposes really. The first one described in paragraph 68 to 70 is to show that for frequencies above about 160 hertz or so, the sound levels inside the bedroom in question were quite a way above audibility thresholds, and so would have been expected to be audible. And the difference between the green and the black plotted lines shows that the wind turbine sound levels were significantly higher than sound levels in the absence of wind turbines. And so that change in sound level, which would have been audible, would have alerted the occupants of the bedroom to the presence of wind turbines. So it would have been clearly audible. Now, the point being made in the evidence to which this refers is all about health impacts being caused by inaudible sound in much lower frequency bands. But this chart is illustrating that it's almost impossible to say one way or another what is causing what, because there's no investigation of confounding factors in the evidence. And this is just one example of one obvious confounding factor that could have affected the results that have been obtained from the data. If the people could hear the wind turbines, then that might have caused them to be disturbed or annoyed, and that could have resulted in the observed sleep issues that are described in the evidence. So there's no way of separating, or at least there's no attempt to separate those things in the evidence. So that's the first point being made by the chart. The second point, of course, is a more obvious one, which is that in the lower frequency end of the spectrum, so we're talking about frequencies, well, let's say frequencies below around 80 hertz or so, all of that sound energy is well below audibility thresholds, and so is completely, expected to be completely imperceptible to any human being. And so the obvious point being made there is simply that that energy isn't perceptible. Now, I appreciate that the whole argument being made in the evidence is that it's imperceptible infrasonic energy which is causing these health issues, but we don't accept that, and we don't believe that this evidence demonstrates that, and there is ample evidence demonstrating that that's not the case. And I've set that out in our statement in the succeeding paragraphs, which I won't take you through in detail now. So I hope that answers the question.
Actually, could I have a follow-up question opportunity?
Yes.
So it is the position of this report that only perceptible, which is synonymous with audible, right, influences are affecting people, right? So if it's perceptible, when you say perceptible, do you mean audible? Because I won't scrutinize you much longer. I just want to refer that, for example, you in this, I suppose you are the author of this report. Your reference, there's a footnote in your report, which reference, I think it's reference 20. Let me just check on page 18, reference 20, Weissenberger paper. Weissenberger paper demonstrates that infrasound is perceived by the brain, even if it's not audible. You have another reference down here. So you see, and again, yes, it's up for debate in the UK. Other countries have legislation against infrasound since the 1980s. So yes, it's under debate in the UK. So there's other references. One of them, let me see, reference 44, paragraph 93. Which is on page 22 and 23 of your report, paragraph 93. If you go down there, it begins in relation to low frequency sound. And the first paragraph, I just went through the first few references that you provide for these statements. So studies have highlighted that wind turbines emit a greater proportion of low frequency sound than is associated with some other common sources of environmental sound, such as road traffic. That is reference 44. It is a paper from 2021. This paper also says, it is also highlighted that allowable wind farm noise limits and associated penalties are often lacking in evidence to support them and remain to be addressed in the future. Wind farm noise clearly has the potential to contribute to human annoyance, sleep disturbance, and potentially to impact health and well-being. This is an example of the references also contained in this document. There are more, but I think I'll just stop there because I'd like to make it very clear to all who are listening, including the acousticians, who, yes, are engineers. I so totally get that joke. That, the engineer joke that every paper is, oh yes, further research is required. As coming from an engineer, I totally get that. But you see, medical sciences is not engineering, unfortunately, because it'd be much easier and we'd all be much healthier if medical sciences were similar to engineering. Annoyance, for example, which is so spoken about, is not a medical outcome. Do you get this? Annoyance is not a medical outcome. At best, it's a symptom. So in terms of medical sciences, so this is part of the problem, right? Evaluating the medical outcome. Annoyance is not, according to medical sciences, is not a valid medical outcome to study. There's other issues here, but that's the medical part. As has already been said here, reproduction of the agent of disease, which in this particular case is a pulsed infrasonic output, from wind turbines, that is very difficult to reproduce in laboratory. So not only are, in general, people are not, scientists are, because you see, medical sciences receives no grants to study infrasound. There's no grants in medical sciences to study the effects of infrasound. Acousticians get grants to give people annoyance questionnaires. This so goes against medical sciences that I can't even begin to express. And as I say, annoyance is not a medical outcome. So you see, when then people who are not trained in medical sciences use papers that purport to study health effects of, in this particular case, wind turbines, they have not the discernment to evaluate whether that particular scientific paper, which purports to study health effects, really does so. And to finish, I will just refer again to the references provided in this Carrick report, namely 47 and 48. These are papers by Frits van den Berg and Irene van Kamp. They are Dutch. They are not medical professionals. And what they do, which is now common practice in science, I'm old school science, I take issue with this. What they do is they go on the internet and they gather all the papers that mention a particular topic that they want to study. For example, in reference, here we go, in reference 48, that is in this Carrick report, these two researchers, whom I know personally, by the way, these two researchers, and they're great people, please don't get me wrong, but these two researchers gathered 355 scientific papers on the subject, and then they only analyzed 32. Because there is this idea that we can exclude, you know, AI and keywords and all of this, so we exclude. This is not science. I'm sorry, and it's certainly not medical science. So we're talking about harm that is being done to people by machines that are being implemented in the human biosystem without any regard to public health. This is what we are talking about. And in a few years, we'll probably compare this situation with that of asbestos, with that of tobacco. It's a certainty. Countries have legislation against infrasound since the 80s, and we're doodly-daddling here. I mean, okay. So again, and I just want to make one more comment, if I may, regarding something that was said yesterday. I think it was Mr. Fraser, and very well he said, this is going against government policy. Yes, it is. What should one do when government policy harms people? What should one do? So I understand there's a lot of economic and political entanglements here, but my issue is the health of the people. That is my main issue, and it's not being protected. So that's all I have to say regarding the Carrick report.
You're on mute, Mr. Bray.
It wasn't very handy for trying to round up your submissions, Ms. Alves Pereira. So you perhaps got more time than you thought you had there, or than I thought. So,
Mr. Bray, I'm sorry to interrupt you. The truth is always very inconvenient, and I'm sorry if the truth took a little more time than it should have.
no, I'm perfectly happy with that, and I think it actually links back into something that Ms. Crosby was keen for us to hear today, and that's a statement from Rita Holmes. Now, I'm conscious that there were suggestions this should have been an inquiry session, and we are having it in a hearing session. It's not necessarily always the case that we would hear from a witness speaking in the way that you've asked Ms. Holmes to speak, Ms. Cosway. But with everyone's permission, if all the participants are willing to hear Rita Holmes' experience, if we say 5 minutes maximum, then I'm quite happy to hear it. I am aware that it doesn't relate directly to the applications that we're dealing with, but you've taken the trouble to be with us today, and we did opt for a hearing rather than an inquiry. So if all the parties are content to hear what Ms. Holmes has to say, then we can move on to that, Ms. Cosway. Everyone seems to be happy. I'm not seeing any hands up or any shaking of heads. So good afternoon to you, Ms. Holmes. I think you've connected to the call. I'll let Ms. Cosway introduce you if you want, Ms. Cosway.
Thank you. Are we just going straight in? It's document 17007, and Mrs. Holmes would like to tell you about her experience living close to these turbines. Thank you, Rita.
Thanks very much, and apologies, I had another meeting at 11, so I did listen all yesterday and for the first part of this meeting, and I found it really interesting. Having read the applicant's hearing statement and listened to statements yesterday and today, I want to talk about the Hunterston wind turbines, because the ones that are proposed for South Ayrshire are going to be probably of that height or larger. I want you to know what the reality is of living next to large industrial wind turbines, and the fact that we are not protected by ETSU R97. And in a way, it's detrimental that that is the only thing we have to regulate them, because there's nowhere I can go other going to court and spending lots of money to get any sort of hearing or justice. Basically, I was one of the lab rats in this undeclared experiment. In all my years, I have never experienced anything as awful as the debilitating effects from the two Hunterston wind turbines. It was tantamount to torture. Every day you wondered if they would be operational and for how long. You wondered if they would turn, especially at night, and where you would be able to escape to. Thankfully for us, during COVID lockdown, they were redundant. The Siemens turbine had operated for longer periods than the Mitsubishi wind turbine, but we never knew when they would operate. So in effect, there was no way of planning ahead to be away or avoid exposure. Now, in a way, it was brilliant that the Mitsubishi worked intermittently, as did the Siemens, because it gave us a chance to feel actually the effects on us, because they would run for maybe 2 minutes and stop, or they'd run for 20 minutes and stop. My home became unlivable when the turbines turned. At least I was aware early on that my ill health was due to the wind turbines. Many people round about did not know, and they wondered what on earth was wrong with them. I did go to my doctor and tell him how I was being affected and how I knew it was definitely the wind turbines, not something that was psychogenic. It was physical. I did phone and write to Health Protection Scotland, now Public Health Scotland, and despite them telling me that my symptoms might well be from the wind turbines, they assured me there was no evidence in literature to prove this. I have since looked at the papers and studies on ILFN and wind turbines, and I've found empirical evidence from all around the world. So I got no help from PHS, no help from Ayrshire and Arran Health Board, who advised North Ayrshire Council's Environmental Health Officer, and no help from our general practitioners, who advised me in writing that their insurance did not cover them for getting involved. I didn't need to see the wind turbines turning to know they were turning or not. My house is actually set back, so I have no view because of trees and various things. But to see the wind turbines, I actually have to go about 50 meters down the garden to be able to see them. So I couldn't tell from my house just by looking at them whether they were turning or not. I didn't need to see the wind turbine to know it was turning. I could feel it immediately. When it stopped, I was fine. When it turned, I was ill. It had nothing to do with me being anti-wind farm or a NIMBY. In fact, I'm the opposite, and I don't mind them aesthetically. As soon as the wind turbine idled before operating, I experienced a single wave of nausea. I felt my balance wasn't right and that I was walking differently, feeling like my coordination was out of sync and that without concentration, I would crumple to the ground. Unlike my next door neighbour, I didn't fall to the ground. She did. At its worst, when SSE were ramping up the power on the turbines together, I could not walk, talk, or think properly. The centre of my brain felt like a drill was whizzing away inside it, and I had to escape. I remember thinking that this must be what whales feel like when they beach themselves. My neighbour was with me at the time, and we both knew we had to get away. She actually had to sit on her bottom to get down the stairs in my house, and I held onto the handrail. I drove us to the doctors. She wasn't fit enough to do it. I felt a bit better. But what can doctors do? They offer you anti-sickness pills and sympathy. I did ask that my ill health be registered by phone rather than having to visit each time a turbine turned. My doctor also told me that Ayrshire and Arran Health Boards claim at a planning committee meeting that there was no epidemiological evidence was irrelevant and invalid, as they had never approached our doctor's practice for information, and there was no code for GPs to register wind turbine symptoms for health board statistics. So at the planning committee, we were actually lied to. Please note, I refer to wind turbines turning as opposed to operating. This is necessary because the company SSE twice tried to discredit my evidence by claiming that I had complained about detrimental effects when the wind turbines were not operational. It emerged on investigation and too late to influence a meeting that non-operational to them doesn't mean not turning. It just means they're not generating electricity. So they were turning, but they weren't generating electricity. So for them to say in a meeting they were non-operational made it sound as though nothing was happening at all, and I was lying about it. They had been idling in the wind. In fact, merely allowing the blades to idle on turbines this size with these huge blades was enough to produce low frequencies, ILFN, which can play havoc, I'm telling you, with a neurological system. The effects of ILFN from these large high-power wind turbines were something one would not wish to happen to any other human being or living creature. So to hear that another community or person might have to tolerate this fills me with fear for those people and anger at a system that allows the injustice of it, due to the lack of understanding from those with no experience of the severe effects and developers and consultant acousticians who maintain against growing evidence and scientific medical papers that there's no danger to health. ETSU R97 is not fit for purpose anymore. It might have been fit for purpose for the normal size turbines when we started having wind energy. It's no longer fit for this size of turbine. We are being let down by everybody who's charged with safeguarding public health. The planning system no longer protects public immunity. I know I was physically impacted by these large industrial wind turbines. For anybody to say otherwise is calling my integrity into question. In all of this, the only people telling me the truth were the Japanese and Scottish engineers on the site the day that I was so desperate I had to go and visit them. I'd woken up at 5 to 7, single wave of nausea, which was the usual. I knew it was the turbine. I got dressed, and by 8 a.m. I was feeling off balance and that I would have to leave the house. I went up my drive and thought, if I go left, go and see the doctors. If I go right, I can go to the site and speak to the engineers if I manage to get onto the site. So I decided I'd go right. Once I got to the control house, I knocked and got the Japanese engineer who took me to the Scottish engineers. I said I was there to complain about the turbines, and the Scottish engineer said to me that he'd been on Fairley Beach, that's where I live, the day before, and hadn't heard any noise. So I said to him, no, I hadn't heard any noise either. And he was as surprised at that. But he said he was skeptical as to whether I was being affected by the low frequency noise. And especially, he said that they had just arrived, the two Scottish engineers, at 8:30, and the Mitsubishi was not operating until about 8:30. I disputed that. And it was the Japanese engineer that came into the conversation and then said that he had switched the blades on to idle and warm up the oil that was needed for the system at 5, just before 7. So it's maybe one time that I can say that was definitely, they told me that I was right. I hadn't seen them. I knew they'd started. I then asked what had occurred on the evening of the 1st of February into the morning of the 2nd of February 2017, because people in Fairley, in the dark, it was winter, it was late, it was in the dark, were wondering what the thunderous noise was. I knew exactly what it was. They were out Facebooking and texting each other and saying, oh, I feel as my chest's crushing me. Oh, what is that? So whatever it was a noise, audible noise, but it was also, there were other things, other frequencies within that noise, that audible noise. Now, initially, I was told when I brought this up with the engineers that they had not been operating at that period in time. So then they decided they would go off and look at the log in another room in the huts. And they came back and said, she's right, we were operating then. So this is what you're up against. Do you actually have to go onto sites and speak to engineers to get the truth? Because we're not getting the truth. We're not getting the truth from the acousticians or the environmental health officer, because they're all relying on ETSU R97, and it's not protect people, especially with these huge wind turbines. So I'm hoping, I think you asked me yesterday what I hoped to get out of this report. I'm hoping that somehow we will be listened to today in this hearing, because ETSU R97 isn't protecting the people. And I really fear for people that have to put up with what we had to put up with. And I'm not alone. There were 17 people affected in our area, some worse than me. So thank you for listening to me.
Well, thanks for that. And I said thank you for keeping it reasonably tight as well in terms of time. We did have permission from all the participants to hear that, although it is perhaps a little bit unusual in a hearing situation. Given that you have said what you have said, are any of the participants, particularly the applicants, wanting to ask Ms. Holmes any questions? Not in a cross-examining way, but are there any questions that you would like to ask, or are you happy that you don't have any questions? I did ask the applicants first of all, Mr. Houston. Any of the applicants?
Sorry, I don't want to interrupt, but hear what you had said.
Oh, you hadn't heard. I just asked if any of the applicants had any questions for you.
Oh, thank you.
So no questions from Craiginmoddie, no.
I'm looking around the screen, Ms. Holmes, and it doesn't look as if there's questions. Mr. Houston wanted to make a point, I think. Mr. Houston? Or you wanted to make a
It's
point?
not a point. It's just a simple question. Did all the symptoms go away when the turbines were removed?
I think you're on mute, Ms. Holmes.
Sorry, I didn't hear that. My screen keeps on freezing. I've not had a problem up till now, but if it was a question, can you repeat it, please, for me?
Sorry about that. I was just questioning, have you experienced any of these symptoms since the turbines have been removed?
No, none. Neither has my neighbour or the neighbours, the other neighbours. We've all been fine. The only time I ever experienced any of the symptoms were when the wind turbines turned. And you could say I suppose you could criticise me saying, well, you know, you knew when they were turning. I didn't know when they were turning. I could actually sit in somebody's house and tell them when they were turning, and they could go and check. And I don't actually think I'm super sensitive or anything like that. I just think that the power and the exposure it's something you feel physically.
Well, I don't think there seems to be any other questions, unless my colleagues have any other questions. We will, we can reassure you that we're looking at all the evidence and we'll be coming to our conclusions. But it may be useful to highlight that we may not be able to conclude on everything that's been presented to us, but we will be able to come to our conclusions on our recommendations to ministers on these three applications. Whether we're able to make any conclusions on all the matters that we've heard today and on all the subjects, then we'll have to wait and see on that. But we were probably going to talk about Knockcronal, which I don't have actually any questions on. I think, Ms. Crosby, you said that you wanted Ms. Holmes to be heard around the time we're talking about Knockcronal. But is there anything else on the Knockcronal hearing statement that you would like to flag up? Because I think all the points I would have liked to ask have been dealt with in other ways earlier or yesterday.
Yes, we do. Yes, can you hear me?
Yes.
Oh, okay, that's better. You have frozen as well. Yes, we do have a point on Knockcronal, and it is page 23, 416 on the cumulative noise map issue.
And is that on the hearing statement? Is that on CD 1228?
Yeah. Mr. Grosvenor will answer that.
Yeah, the paragraph 4.16, there's a suggestion that, you know, we asked for, Safe Scotland asked for a cumulative noise map covering all the proposed developments and number of existing wind farms. However, Safe Straighten for Scotland did not detail what deficiency they identified with the assessments and why the additional information is necessary to justify such a request. The reason for the request was so that we could see from the cumulative map whether there were any deficiencies. It wasn't that we should be expected to establish whether there were. Without a cumulative map, we didn't know. So that's the issue. And of course, that hasn't been answered. So we're still concerned about this, and we still consider that information is outstanding.
For any of the applicants, but perhaps Knockcronal in particular, is there anything from your work with regard to cumulative impacts that you would like to respond to the point that Mr. Grosvenor has made?
Yeah, I can clarify that the method of assessing cumulative impacts is following the IOA Good Practice Guide. That has been followed, and the general assumption is that if you are looking at sources that are 10 dB below limits or 10 dB higher than another source, then you need to look at the acoustically relevant wind farms put in a particular receptor location. That's the process that was followed in all three assessments and carried through into the statement of agreed matters, where we look at those wind farms and sources which are acoustically relevant. So that deals with which sources you would include. So you wouldn't, for example, be looking at including wind farms at significant distances away, such as Atholl Valley and Trelorg being included in that assessment, because they're just simply so low in level that they don't add any acoustical relevant effect to the totals. And then which receptor locations you look at. To R97 is clear that you assess the noise at the nearest receptors, and that's what we've done. So that's the approach to assessing cumulative impacts, and we believe that we've followed the good practice guide and to R97 in undertaking those cumulative assessments. So I think if more information is required on assessing cumulative impacts, it's why was what was done deficient in allowing you to understand the cumulative situation if what we've completed was what was actually required by good practice guide and net 97.
Do you want to speak to that?
Yeah.
Well,
Mr.
what we
McKay?
have in terms of the cumulative maps is there's a figure with the sound power contours. I haven't got the actual reference number to it, but we had a map which showed a regular line at a certain distance. Yeah, I've got it here. It's figure from Carrick 9.3 noise contour.
Is that the Carrick EIAR?
Yeah. Yes.
And figure
9.3. It's a noise contour 10 meters per second, all cumulative developments operational and proposed.
Can we have the CD reference for that?
It's at the top, is that? Yeah. CD reference 002069.
That's from the Carrick application. I think Mr. Mackay was wanting to make a point. So before you carry on, Mr. Grove, I'll allow Mr. Mackay to come in and you could respond after that. Mr. Mackay? I think you're on mute.
Thank you. I think Mr. Jiggins provided a very useful answer there, and I would agree with what he said. The only additional point I would like to make, which will hopefully reassure some of those on the call, is that for this particular inquiry, the noise modelling work that's been undertaken is probably more detailed than the vast majority of assessments that you might see. In fact, 3 completely separate and independent noise assessments have been undertaken to consider the properties. One by Mr. Jiggins, one by Mr. Paulson, and one by myself. So, we spent quite a bit of time comparing our relevant predictions and the approach we'd all taken to cumulative noise, and we were all in agreement. So hopefully provide some reassurance. It has been considered in detail. We all followed the same guidance, and we all came to the same conclusions.
Do you have other points on? Oh, I think Mr. Paulson has got a point to make.
Yeah, thank you. So yes, it was just to highlight that all of the 3 completed cumulative assessments addressed cumulative noise in the manner that Mr. Jiggins has described. If I could just draw your attention to the panel report for the Carrick wind farm, that's CD 2189 and paragraph 9.6.5, which summarises the review of the technical review undertaken by ACON. And it says that ACON, midway down the paragraph, ACON agree with the approach to the cumulative assessment and the setting of the site-specific noise limits, and agree with the conclusions in the EIAR. So there's a clear acceptance there of the cumulative assessment approach, and that approach was common across the 3 developments also. With regards to figure 9.3 of the Carrick EIAR that Mr. Crosswaite referred to earlier, That is a cumulative noise plot. It simply shows the extent of the noise modelling work that was undertaken. The assessment itself, the plot is large enough to cover all of the receptors that were considered in the assessment, and you can see that they're scattered around the proposed development in different directions. The plot itself isn't there to show the expanse of cumulative effect or to look at cumulative effects at massive distances, because that's simply not required. It's just to show that the modelling approach and the amount of detail that went into the model to ensure that the calculations at the nearest receptors were.
Thank you, Mr. Pilson. Any further questions on the Knockcronal hearing statement from Save Strain for Scotland?
You come back.
Well, I just would like to continue a little bit further with this map, because the thing is that what we've got here, I understand how we've discussed the noise modelling, and acoustician Mr. Hooson obviously has gone into that in great depth. But the problem we have with this is that, you know, we've got a cumulative noise map which shows precise lines across the map. It doesn't really reflect any barrier attenuation. It doesn't really reflect any topographical influences. And when we look at our maps on page 51 of our inquiry reports, which do show topographical highlights, it's clearly evident from those our maps that topography is a real issue. And of course, if you look at Little Garrett, which we referred to before, you can certainly see a very high value effect going straight up towards where Straighton is. So that is a concern, but we don't see that explained in this map, although you do talk about propagation and you do talk about assessments and evaluations and all the rest of it. But where is the evidence in a simplistic map form where we can see how the sound will propagate you know, through the valleys and so forth? We don't see that. That's the problem we've got. Maybe it's being simplistic, but you know, if local residents want assurance that their amenity is protected, then that will be more helpful.
I think Mr. Pilson and then Mr. Jiggins were wanting to respond. Mr. Pilson.
Yeah, sorry. Thank you for the opportunity to respond. Just to reiterate the point. So, on that figure 9.3, it's there's a call out box at the bottom of the figure that confirms the effects that are taken into account in that plot, and it does confirm that the plot represents a flat topography and so on. That plot is just to show the extent of the noise modelling work that's been undertaken. The actual assessment, numerical assessment that's presented in tables and documented within the assessment, and subsequently brought forward into the SOAM and so on and so forth, applies the prediction method, taking all of topography and screening effects fully into account. That's detailed within the appendix to the chapter. I've just looked at which appendix it is, but it's entitled Noise Prediction Method. It's appendix 9.2 to the chapter, and that confirms the modelling approach and that all of the calculations were undertaken in full accordance with the IOA GPG, including the topographic action, etc.
Okay, Mr. Jiggins, where are you wanting to make an additional point? I see your hand is now.
Yes, I suppose I can just a general point really in terms of the utility of these types of noise maps. So whilst it can be useful in some aspects in showing general noise levels, I think the point is that we are required to do an assessment against ETWA 97. So an ETWA 97 assessment requires that you assess noise levels against noise limits. Those limits are different day and night, and they are different at each wind speed. They're also different at each location. So whilst the noise map can show some simplistic information at one particular wind speed for one particular scenario of which sources you've included, it doesn't allow you to actually do an assessment according to ETWA 97. So the utility of a noise map is fairly limited in terms of understanding whether you're compliant with the requirements of ETWA 97. So that's part of the reason, I suppose, really why noise maps are not the be all end all of an assessment, because they don't allow completion of an ETSU R97 assessment. So therefore, the majority of the assessment work that's been done is using charts and tables and comparison tables of predictions as set out in the statement of agreement, and that's the appropriate way of determining whether the applications are compliant with ETSU R97 rather than a noise map.
Okay, thank you for that. So I think we've had the answers on your question on the noise map, Mr. Grosvenor, so we can move from that. Are there any final questions on the Knockcronal hearing statement? Mr. Houston? Final question, perhaps, before we break for lunch.
Okay, a very quick one, and it's common to all three hearing statements, basically. It was mentioned earlier that it was suggested that there shouldn't be an amplitude modulation condition, and the Craiginmoddie hearing statement CD012.026 in section 8.10 takes a quote out of the Institute of Acoustics Good Practice Guide in section 77.2, and it's where it's extracted. It states, current practice is not to assign a planning condition to deal with AM. The following sentence in that statement is that SAC and ACON have not presented any evidence to justify a departure. Now, this is despite them suggesting that there should be a condition regarding AM. And the point I would simply like to make is that the Institute of Acoustics Good Practice Guide was formulated in 2013, so that's 10 years ago, and it's referring to, quote, current practice is not to assign a planning condition to deal with AM. We're now 10 years on, and we've learned a lot more about the adverse effects of amplitude modulation. I'd just like to highlight that the defence that because the GPG suggests that current practice is that is 10 years old. That's one issue. The other issue is regards to
just on that
the
matter,
Knockcronal.
I think I won't ask that. Let's respond because we will discuss that with regard to planning conditions. And just as a little highlight for that discussion is that it's likely only to be half of a discussion. The council are not present, so we will probably continue a discussion or complete our discussions on conditions in the conditions hearing. But we'll discuss what we can today on planning conditions. But that's just a note for everyone that it may not be a full discussion because the council are not here and there is a scheduled planning conditions hearing. So I had planned that we may break for lunch, but Ms. Houston, I think you had one additional point to make. Was that on the Knockcronal hearing statement?
Yes, it is. So in section 4.41 of the Knockcronal hearing statement, CD 012.028, paragraph 4.41 under other matters, it refers to one of my papers where I have identified that the use of sound level meter data in background charts may not comply with the requirements of ETSU if the data points that are extracted from the sound level meter are below the measurement range of that sound level meter. So what's explained here in the Knockcronal report is a discussion of the impact upon background noise trend lines that set target noise limits. Now, it's just highlighted my paper here, and it goes through explaining what my paper is about, but fundamentally it ends with, I'm therefore satisfied that this is not a significant consideration. Now, the issue with ETSU, if we're going to be doggedly observing every word that it says that when you use a sound level meter, the sound level meter has to comply with IEC 6172 part 1 or 2, depending on the type of meter, but it has to comply with that. And in compliance with that, you have different types of accuracy of different sound level meters. So you have class 0, class 1, and class 2. Class 1 is recommended for ETSU use, and class 1 has a tolerance of its accuracy in measurement. Now, that tolerance for it to be classified as a type 1 instrument has to measure sound levels accurately within that tolerance level. That tolerance level is defined as being applicable to a measurement range from the sound level meter. So the sound level meter has a measurement range, and then below that measurement range is an area where it will throw out numbers to you, but the numbers don't comply with the type approval in accordance with that IEC standard. They are below the accuracy range in which the meter is type approved. So from the lower sound level of the measurement range of an instrument down to the noise floor of an instrument, that is typically about 10 decibels. So when you see the noise floor of an instrument being shown on scatter charts, you generally see, and this, if we can refer to the Carrick wind farm statement, CD 012.027. The issue is passed on to this other statement, and Annex C discusses noise measurement system noise floors. And the issue of the noise floor is effectively relevant to the credibility of setting background noise level trend lines and whether target noise limits should be assessed based upon those trend lines. So what you're doing is saying, have we got confidence in the background data scatter charts? And that's what NXC is looking at, and it gives examples of a number of scatter charts which show the effect. So, for example, in the Annex C of the Carrick...
Sorry? I'm keen just to understand your main point with regard to the Knockcronal hearing statement. So, I mean, if you could summarise what the main point is. Yep. I don't want to be lost in the technical details of it. And just in case I miss your point.
All right. So the point is, I believe that if you don't consider the limitations of the measurement instrumentation that you're using to measure background data, it could have an adverse impact on the trend line that sets your target noise limits. In the Knockcronal statement, it's stated that the author is therefore satisfied that it is not a significant consideration. And likewise, the Carrick wind farm statement also echoes that statement, that they don't believe that it has any significance on the outcome. And I contest that quite simply by looking at Annex C. And if you look at the last chart, which is showing...
So Annex C of, Mr. Hudson, Annex C of? Annex
C of CD 012.027, the Carrick wind farm hearing statement.
Could you repeat the internal reference again, please?
It's the last 3 pages of the report, and it's Annex C.
Thanks, we've got that now.
So the suggestion in these 2 hearing statements is that it would have no significant bearing on the noise assessment results. And this is where I differ, in my opinion. So if we look at the 3 charts that are presented in Annex C, there are 2 example charts of scatter data that have been prepared using sound level meters, including all of the data that comes out of the sound level meter. So the first chart shows data down to approximately 18 decibels, and the second chart shows data down to 15 decibels. So these are effectively the noise floors below which you don't get any reading from a meter, from a sound level meter. Now, the measurement range to which a meter is classified as being accurate to a certain standard is normally about 10 dB higher than the noise floor. So all it means is that on the first chart, data is shown from down to 18 decibels. So the data up to 28 decibels is effectively compressed. In other words, it's artificially higher than it should be. Now, because it's artificially higher than it should be, it's effectively increasing the height of the trend line in that region. So the real data from actual sound, if the instrument was capable of measuring much lower, would be much lower than 18 decibels, which the instrument can't measure below. So ETSU requires a certain standard of instrumentation. The standard of instrumentation is only applicable in its measurement range. The measurement range is 10 dB higher than the noise floor. So the measurement range for this instrument would be down to 28 dB. And for the next example on the next chart, the measurement range would go down to 25 dB. So data below 28 dB on one chart and below 25 dB on the second chart is all artificially compressed higher than it should be. When you then put a trend line through it, effectively in the areas where you've got these low levels, the trend line is artificially elevated. When you have a background plus criterion setting your target noise limit, that then can affect the target noise limit and artificially elevate it in some circumstances.
So, do you think you've made your point sufficiently so that could bring in the applicants, I think, to respond to the point? I think, I've been looking at the charts, and I'm sure they have as well. Mr. Poulsen was almost waving at us. He seems super keen to respond. So, if I can ask Mr. Poulsen to respond in the first instance.
Thank you. Yes, I'll try and be brief, although it is obviously a technical matter. So just to highlight that the first chart shows the measured noise level data, which comes out of the noise meter, if you like. The purpose of the second chart is then to say if the lowest noise levels that were measured by the meter were subject to any effect or limitation as a result of a noise floor, then if we take that noise floor away from the data, then acoustically take it away as a value, then this is the new scatter graph that would result. If we then flip over onto the next graph, it then compares the 2 lines, and as you can see, the red line, which is the data with the noise floor correction made, is lower at lower wind speeds than the black line, and I think that's the point that Mr. Hudson is making. But what the graph actually shows is that when you apply, well, first of all, that all of those measurements are much lower than the fixed element limits of the ETSU R97 limits. So they're the lines that are straighter and higher up in the graphs, and tack across at 43 decibels in this example. So you can see that where the lines are different, if you were to take this as an issue, the effect on the applicable noise level limit is 0, because the limit of that wind speed range is dictated by a fixed element and it's unrelated to the measured background data. If you then look at the inflection of the lines, because the red corrected line is lower at low wind speeds, it starts to rise and ends up being slightly higher at higher wind speeds, which results in a further worsening of the resulting limit where the background element dictates. So to highlight that point, if we look at the two limit lines, which are the limits that run as a straight line across at 43 decibels, you'll see that the limit then starts to rise to about 10 meters per second, which is where the background noise level +5 element of the limit takes over. And if you adopt the data without the correction made, you'll see that the limit becomes more stringent because it's lower in the chart than the dashed line. So essentially it's precautionary. Actually, in this instance, the approach adopted is cautionary in terms of the resulting limit. My last point is just to highlight that all of the measurement equipment deployed during the baseline noise surveys were Class 1 specification measurement equipment as required in the IOA GPG.
Mr. Jiggins, I think you wanted to come in.
Yes, thank you. So just to refer back to my hearing statement and following on from what Mr. Paulson's just said, to clarify therefore where I am satisfied it's not a significant consideration, is to refer to the sentence prior to that, where I highlight that I have looked at this effect on the lowest background levels measured during both daytime and nighttime at Knockcronal, and then done a similar calculation to what Mr. Paulson is showing here, and I found a similar outcome for both the daytime and the nighttime limit. I didn't show it in my evidence for brevity, but Mr. Paulson's provided a full analysis there as an example. So when I say that it's not a significant consideration, it's not a consideration in terms of the derived ETSU limits. So whilst I can agree that the background noise levels at low wind speeds would likely be lower were there not to be an influence of the noise floor, in some circumstances where you're measuring very quiet environments, that there wouldn't be a consequence for the assessment outcomes. And that's where I'm satisfied that there's no significant effect on the assessment outcomes. And just to clarify, that's what I was referring to. If you read that paragraph in full, that's paragraph 4.42 of my hearing statement, which is CD 1514.
Thank you for that. And the reference, Mr. Jiggins. Do you have your hand up again, Mr. Jiggins, or you've just taken it down? That's fine.
Yeah.
Mr. Hewson, were you just about to? Was that all your points? One more. I see.
Yes. So 2 points. First of all, with regard to the Carrick applicant, the correction methodology that was used is simply the logarithmic subtraction of one L90 value against another L90 value. Mathematically, that's nonsense. You're not supposed to take L90s from L90s. You can't do that with statistics. If you were to do it properly, what you have to do is look at the individual, let's say, 1 second LEQs that make up each 10 minutes. You correct each of those 1 second LEQs in terms of LEQ. Then you have to reprocess them as an L90. So technically, that correction methodology isn't correct. But if we do assume that it was correct, if you look at the last chart, it does show a target noise limit of 43 is being used. And in that situation, certainly there is very little effect. However, if the nighttime target of 38 is used, or the daytime target of 35 is used, then there is a material effect. And the difference, if you, for example, use 35, go across and 5 dB above, there's a 1 dB criteria, which is where it would kick off at the inflection point. So depending on the target noise limits that are used, there could be an implication of 1 dB on the target noise limit. And what I was explaining in my hearing statement was basically that if you have a margin of 0 for number of properties, not all of them, of course, then that could be a significant thing that you should consider.
Mr. Jiggins, you had your hand up first, and then Mr. Prost.
My hand down before I start this time. Yeah, just to come back on that, I think that what we should observe about that 1dB that Mr. Hudson is noted there is it would only affect the inflection point Mr. Paulson's highlighted before. It would not be a 1dB difference across the whole of the range of the limit. It would be a 1dB difference for a small part of that curve, potentially. But as I said, I have looked at this at the quietest location that we measured at Knoxgay, and I did not find that when deriving the 38 dB limit during the day and the 43 dB limit during the night. And that's where I make my conclusion from.
Mr. Coulson.
Thank you. Yeah, so just a very quick point of response. So the example that we presented within Annex C of the hearing statement was specifically selected because it was the location that had the very lowest measured noise level during our survey. So it was the place where we thought the effect might be most pronounced if we were to consider it further. That's what we've done. And I think Mr. Jiggins has already mentioned that he's also undertaken the same assessment for both daytime and nighttime periods at the receptor of Knoxgay and found the same effect. And obviously the daytime has the lower limits also.
Well, that appears to me to be the points that people wanted to make before we moved on to consider Ms. Trainor's concerns. But I think we'll do that after lunch now. We have one hand. I will let come in for Carrick.
Thank you. Yeah, sorry, it was just one point I wanted to make in response to the views expressed by Professor Alves Pereira earlier on. We heard from Professor Alves Pereira that annoyance is not a health outcome. I just wanted to draw your attention to CD 1232, which is the World Health Organization Environmental Noise Guidelines for the European region, and on document page number 11, PDF page number 31, at the top of that page we can see a list of health outcomes. On the left hand side we see a list of critical health outcomes, and number 2 in that list is annoyance. And then in paragraph 1 it states that the WHO's constitution includes the phrase health is a state of complete physical, mental and social well-being, and not merely the absence of disease or infirmity. So it's quite clear that the views expressed by Professor Alves Pereira are out of step with the opinion of the World Health Organization on that point.
Thank you for giving us that reference. Mr. Mackay, put your hand up.
Thank you. Just a quick query, and apologies if you were going to cover this shortly, Mr. Bray. I think you mentioned that we might discuss a list of core documents that are going to be relevant to Trainor's discussion. So just to request that we get those again so we can all get the relevant documents handy for the session after lunch.
Before we do that, I think Ms. Crossway has got her hand up.
It's just to say that Professor Marianne Alves Pereira would like to respond, please.
Oh, yes, I do see her hand. Ms. Alves Pereira, would you like to give a short response?
Yes. Annoyance may be considered a health outcome by the WHO, but annoyance is not a in medical science. Annoyance is not a health outcome. Would you like to know why? Because it is subjective. The science axioms require that any medical outcome that is to be analyzed under bona fide science be a objective measure. So just to make that clear. Obviously, in the world of psychology, that's a whole different story. But we're talking about actual biological cellular damage. And in that respect, annoyance is not a medical outcome. I will challenge anybody on this. The axioms of the scientific method do not allow it to be. Thank you.
Thanks for making that point. I do plan now to break for lunch. When we come back from lunch, we had said that we would take questions on the submissions that have been made by Ms. Traynor before we go to item 9. Now, I would like to double check that the main submissions, Ms. Traynor, are contained within a document that's called, I think it's CD 121. That's the letters of objection. They've all been grouped together. And I think your main points on noise are on page 159, page 28 of your own submission, but electronic page 159 of CD 121. I don't know if you have all these references to hand, but it's your submission on proposed Craiginmoddie wind farm, and you have a chapter of comments on noise, and it's on those ones that I've got a couple of questions, and that may turn into a bit of a discussion around the points that you'd like to make. Is that the correct document that I'm looking at?
Yes.
Yes, it is. Okay, that's good. Hopefully that's provided the applicants, in particular Craiginmoddie, the opportunity to review Ms. Traynor's comments before we have a discussion after lunch. I'm conscious that I'd said we were going to finish at 4 o'clock. I do aim to do that, so I'm going to propose a slightly shorter lunch, so we'll come back at 1:45, unless that's going to be particularly difficult for people. I hope you would agree to that. So if we come back at 1:45, and we'll see you then.
Oh my.
That's 48 minutes past. Can I just double check that everyone's in the room? We expect to be in the room. There's Mr. McLeod coming back, so it looks as if everyone's in the room. Please tell me if they're not. And moving on to an additional item which I've added in is just this morning to consider the submissions of Ms. Traynor, which were submitted on Craiginmoddie wind farm. Ms. Traynor might be aware that TNE also for Carrick submitted additional information which we've discussed over the last 2 days, but I thought it might be useful if we just allow the applicants to respond to the points that you've made. Ms. Traynor, I mean, you make a number of comments around background noise and your concerns around how that has been derived. You set out in bullet point form, if you like, the failures you feel the applicant has made and a number of inaccuracies with regard to mapping and such like. Rather than asking you to summarise or go through your points, are you happy, Ms. Traynor, that I just ask Craiginmoddie applicant to respond to your submissions on any points that they wish to? Or are there any particular matters that you would like to ask them, or are you happy to hear their answers first? Ms. Traynor.
Yeah. Hello. Can I first of all say that I'm extremely nervous about this whole process. I'm unfamiliar with it, and I would appreciate your support to keep me on track. I'll be very brief. I have 4 things I want to cover. I have general concerns. Number 2, the background noise readings. Number 3, our complaints that we have lodged regarding Haggard Hill. And number 4, background noise for Glenalla. That I have specific questions. Maybe I could cover the complaints section. I really just want to share our experience in the complaints section, which is next.
I think that's a good idea.
Okay, so
I agree with that. So would you like to summarise what your general comments are and on background and on Glenalla, or would you be happy to hear the applicants first of all in response to your submission? It's really up to yourself what you feel confident about.
Sorry to cut across you there. It would be helpful to me if I can explain my general concerns and then let the applicant respond to specific matters.
Yep, I'm happy with that. So your general concerns on noise.
Okay. First of all, I'm not an acoustician. I don't pretend to understand half of all this technical data stuff. But I have experience that the acousticians don't have. I have lived for 17 years as a close neighbour of the Haggard Hill operational farm. So I'm well aware of the noise levels, how the noise travels across the valley, how it bounces off the hills back to our home, how it travels down the valley, how it gives rise to complaints. I'm very familiar with all that. The acousticians don't have that knowledge. They're working with data sets, paper, etc. They also refer to NMLs, etc., and receptors as properties. Can I just highlight that it's not just properties, it's people. It's our home. It's everybody else's home. So to talk in abstract terms, I think, is fine. But you have to keep in mind that there are people at the end of that. I have a major concern in that the Haggard Hill, which we currently get a lot of noise from, is off a lot of the time. It's constrained frequently. if the Craiginmoddie proposal is given consent, my understanding is that they will have battery storage, in which case the turbines for the Craiginmoddie application will be on all the time. So we will get the excessive noise that we get at the present moment all the time, whereas at the moment, Hadyard is off quite a lot of the time. Those are my general concerns, and I'm happy now to let the applicant respond to everything else, if you're happy with that.
Yes, I'm happy to open it to the applicant to respond to any of those general points, but also to deal with the points made about the collection of background noise and the failings that are identified. I think it's on page 31 of your submission, which is electronic page 162. There's a number of failings there, and that might be useful for the applicant to refer to. So if I can hand it over to the applicant to respond to that submission.
Okay, thank you.
Thank you very much. I'd like to start by noting that I do appreciate the concerns that the residents, that Ms. Traynor and other residents at Dobbington have raised, and other concerns raised by residents. I appreciate that they're very concerned. Some of the concerns that were raised, which we'll come on to, relate to the approach used to gather background noise, which was used to assess some of the properties. Regrettably, despite spending quite a bit of time discussing this when TNI and myself were involved in the original Hadyard Hill extension background noise survey, regrettably, I was unable to reassure Ms. Traynor at that stage that the methodology adopted was appropriate, but I would note, as I'll come on to, that the council's appointed noise experts, ACON, were satisfied. We did spend quite a bit of time trying to explain it. I totally acknowledge it's a very technical subject. I will repeat some of the things that I've said previously today. In relation to more general points, matters relating to the noise emissions of Hadyard Hill, the existing turbines, I'm not really in a position to comment on. That's really a matter for the operator of that scheme. What I would, however, note, acknowledging Ms. Traynor's point that the turbines are off for a proportion of the time, I would note that in our assessment, and indeed the assessment which informed the statement of agreed matters, we assumed that the turbines were on and operating at full mode at all times. So in that respect, our assessment should therefore be worst case in relation to the existing Hadyard turbines. More specifically in relation to background noise, because I appreciate this is a key concern, it is something that I've covered in detail in several places in my hearing statements. And if you're content, Mr. Bray, I'll take you through the relevant references and a summary of those points. So to start off within my hearing statement, and that's core document 1226, and specifically in paragraph 7.49, which is on page number 21.
Are you able to have those documents in front of you, Ms. Traynor?
No, I don't have any of them.
Okay, so I think if you just explain then, Mr. Mackay, as we go through, just conscious that Mr. Traynor doesn't have to hand the documents. I'm certainly taking a note of the references, but just bear that in mind.
Absolutely, I will try to summarise the information that's contained in these references. Although for brevity, I propose not necessarily to go word for word, but in the preceding paragraphs, I explained that for the original Hadyard Hill extension background noise survey, we monitored at 5 locations, and I've explained the location of those 5 locations and why they were selected. In that paragraph 7.49, I've noted that following the submission of the planning application for Hadyard Hill extension, the occupiers at Dobingston queried the suitability and use of the data collected at what we call NML1, Noise Monitoring Location 1, which was at Knockcronal. We had used that as a proxy data set for Ms Trainor's property at Dobingston. And in Ms Trainor's objection to that, which I think is partly repeated in the information in core document 001121, which is the reference we were given just before lunch. It was noted that whilst we accept the presence of a watercourse in close proximity to Dobingston could have influenced the decision, and by that I think it's the decision in terms of the choice of monitoring locations. It goes on to say, on-site inspection would have shown that the watercourse is actually at least 50 metres below the level of the house, and is located in front of the farm buildings at least 40 metres west of the house. Any noise generated from the watercourse is in fact inaudible in the house courtyard in the east of the gardens. This surely indicates that the presence of our courtyard, which is screened from most noise sources and is constant use for rest and relaxation, should have been required for noise monitoring to be carried out at Dobingston, but the results could not be used for any other dwelling in Area 1. Area 1, by way of background, was in relation to how T&I had grouped the properties when we were consulting the council in relation to the choice of noise monitoring locations. So in response to that point, T&I then undertook additional noise monitoring in the courtyard, as agreed with Ms Trainor and the council. That was undertaken during periods where the Hadyard Hill turbines were switched off, and was included in an ES addendum for Hadyard Hill extension. Following submission of that ES, in fact, in advance, I think, actually, of the ES addendum being submitted, Ms Trainor had highlighted that it had been very wet during the period where the monitoring was undertaken, and had suggested that the data was being adversely affected by noise from the watercourse that was next to the property. Our original justification for choosing Knockcronal NML1 to represent the areas because it was situated away from the watercourse. That was one of our main reasons for choosing it to represent Dobingston. But nevertheless, it was suggested that that data had adversely affected the noise measurements undertaken at Dobingston, and that the data was therefore unsuitable. In Ms Trainor's submission, there is a number of points that are made regarding the suitability of the data, and actually a section of a letter that T&I produced to outline exactly what we'd done is included. Apologies, there's no electronic page numbers on this, but it's page numbers of Ms Trainor's submission are listed, and you can see that it goes up to 43, and then there's a number of figures after that. So there's NFig 10, noise figure 10, I assume, which is actually a copy of the letter which we submitted to Ms Trainor to explain why we thought what we'd done with the data and why we thought the data was appropriate. Now that goes into a fair bit of technical detail, which I'm very, very happy to discuss today, if that would be useful. That particular letter doesn't actually include a lot of the appendices, or the selected parts included don't include the appendices. But for clarity, the full letter was included as a standalone document, and I shall get you the reference for that now. So the full letter is included as core document 1231. It's the same letter, just with the appendices. In short, to summarise what that letter explained, is we looked at data collected at Dobingston. We looked at the data collected at the original noise monitoring location, Knockcronal. We analysed the data in detail in relation to rainfall and potential impacts on the noise levels that were derived. We took account of the logs submitted by Ms. Traynor and highlighting periods where she felt background noise was atypical. And we also included a time series of the data showing exactly what levels were measured when, so that could be seen how those levels varied over time. So quite a detailed submission. Although I totally appreciate very technical. I would say, in fairness to Ms. Traynor, she looked at it in a lot of detail. In my opinion, I totally appreciate she's not an acoustician, but did show a good understanding. And we had a meeting attended by myself, a colleague from TNEI, 2 members of staff from SSE, the developer for Hadyard Hill Extension, and a member of the Environmental Health Department at the council. We went through that in detail, and there is some correspondence relating to that. And forgive me, there's so many references, I'll just find the right one. So in core document 1233, which is the ES addendum relating to noise, which was submitted for Hadyard Hill Extension. In back of that, it's page 37 of 89 in terms of the PDFs. There's an email at the bottom of that, page 37, from Steve Summers, the council's appointed noise consultant at ACON, to a lady from SSE who also attended the meeting, called Claire, where Steve confirms in his email, which is 9th of January 2017, he says, "I confirm that the minutes are a reasonable summary of the meeting. Thank you for sending them across." In the subsequent pages, 2 pages on, you'll find the start of those meeting minutes, which are included in full. And of particular note are points or numbers 15 and 16. And I can read those out for the benefit of anybody who doesn't have the documents to hand. JMK, which I think is myself, advised that the residents at Dobingston are very concerned about noise from the proposed development. TNEI have spent a lot of time with the residents, and the residents have spent a lot of time reviewing the guidance. Further concerns raised regarding a number of storms during the measurement period. However, analysis showed no lag in the time series. I mentioned the time series earlier, to reflect the impact of rainfall, or banding in the data on the scattergraphs. Banding in data on scattergraphs often occurs where a river goes into spate and stays that way for quite some time. The data would appear on the scattergraphs, some of which we were looking at a short time ago, as a band, and that's usually an indication that a river is having an impact. It goes on there. Sorry, I'll repeat that. However, the analysis showed no lag in the time series to reflect the impact of rainfall or banding data on the graphs, as might be expected, in line with examples in SGN2. And SGN2 is Supplementary Guidance Note 2 from the IOA GPG, which is core document 21, I believe. Sorry, 22. The notes go on to say it's a good correlation between the data collected at Knockcronal, which was not collected during a storm period, and Dobingston, suggests the data is representative. TNEI, I think it is a robust and suitable noise survey. SS, and that is Steve Summers from Acon, confirmed that everything he has read is happy with the measurements. On behalf of the council, the measurements are acceptable. There is no dispute of Dobbingston. It then goes on to discuss the ground noise data that should be used at Knockcronal. So Mr. Summers confirmed that he's read everything and he's happy with the measurements. I know he attended the meeting there as well. And as I said in the meeting previously, he confirmed his agreement with the minutes. Just to try and bring that back to the current assessment. In relation to Craiginmoddie, the reuse of the data was discussed with ACON again by the noise consultants who were originally appointed to do the ES and the ES addendum for Craiginmoddie wind farm. So that's a company called Wood. And going back to my hearing statement, which is core document 12026. In paragraph 7.55, I say during the submission of the ES addendum, the data set collected at Dobbingston was also presented and discussed with the council's noise advisor. The use of background noise data collected for Hadyard Hill wind farm extension within the Craiginmoddie noise assessment was considered by the council's noise advisor ACON. The SSE regulatory panel report, core document 120, dated 3rd of February, noted in paragraph 9.6.1 that ACON queried the use of the previous background noise data carried out in 2015 for the Hadyard Hill extension, the methodology used in the assessment of wind shear and choice of cumulative sites. That was in relation to the ES. However, satisfactory clarification on these matters, was received from the applicant's agent and included in the additional information submitted in November 2020. Based on the explanations provided by the applicant, ACON have advised that there would be no unacceptable impacts subject to conditions governing operational noise limits based on the noise limits adopted in the environmental impact assessment report. So in summary, I do recognise that Ms. Traynor was concerned at the time of the Hadyard Hill extension application. Monitoring was specifically undertaken at her property at a location agreed with her to try and address her concerns that the proxy data set we'd used originally was unacceptable. That data, as explained in the TNEI letter to her, showed good correlation. It was discussed in detail in a meeting with the residents and the council's noise advisor. The council's noise advisor confirmed for the Hadyard Hill extension project that it was suitable, and they reconfirmed that in relation to its use for Craiginmoddie wind farm. Whilst I appreciate that hasn't necessarily alleviated Ms. Traynor's concerns, and I genuinely wish that I could have done so, I am confident that the data set is suitable and robust. In relation to other points that were raised, I note the point about properties and people. Clearly, ultimately, the aim of any assessment is to recognise the inhabitants of any dwellings. Apologies if the terminology that's commonly used doesn't make clear, but ultimately that is what the guidance is designed to do. Just in the context that obviously multiple different people can live in a location. I note that we'll consider complaints in the subsequent section, so I don't propose to come on to that. In relation to Glenarla, I know that property is quite some distance away from Dobbingston, so very happy to discuss that particular location. But I would note one of the fundamental principles of ETSU is that background noise measurements are undertaken at properties. There's no requirement to take the lowest noise levels measured across a particular site, or in that case, various sites. The assessment at Dobbingston and at Knockcronal has used data collected at those locations to represent their background noise levels. And I'm content that that's the appropriate way to undertake the assessment in accordance with ETSU. So whilst I'd be happy to discuss Glenarla, I I see no reason why that would change my conclusions that the data sets collected were appropriate. I appreciate there's a number of points raised in Ms. Trainer's submission. I also would note that some of them specifically relate to the Hadyard Hill extension application. I completely understand why Ms. Trainer's reused a lot of the same information, but I clearly don't intend to respond to points raised regarding coordinates for Hadyard Hill extension, for example, because that's clearly not relevant to the current inquiry. I can go through and I've tried to pick out points which I think might warrant a response, but equally, I don't know how you want to progress with this point, Mr. Bray. Would you like me to continue to highlight key points, or apologies, you're on mute.
My apologies about that again. If you've highlighted points that you feel haven't been covered in the hearing so far, I think that would be useful. Things that are specific to this presentation. I'm happy to hear that. I think if Ms. Trainer's happy to hear that, then if you've picked out a number of points, then please do that. But we have heard your views on compliance with ETSU and the guidelines and such like. So I think the important matters for us is to hear points that haven't been covered already in the hearing so far. So I'll leave it with you just to highlight a few points that you feel haven't been addressed thus far, and then we'll let Ms. Trainer respond.
Thank you. I think there were a couple of points raised at the top of page 30, which I just wanted to page 30 in Ms. Trainer's submission, which I just wanted to comment on briefly, if I could. The second bullet point there talks about the operational wind farm and the changes to that. Just to reiterate, we've assumed that all the turbines are operational, so that has been accounted for. I know in the following point as well, there's a comment that at Whitehall, the dairy farmers increased the size of their herd and built an extensive new area to house 200 cows, which it suggested increased the local noise levels. I would note, by using the data collected in terms of background noise levels before that was collected, that should therefore be conservative, because the lower the background noise levels that are used, the more stringent the noise limits. So hopefully that goes some way to reassure Ms. Trainer. So if existing background noise levels have increased during that time, then the data we presented should be conservative. I think most of the other points that I'd raised have been discussed in general terms throughout the rest of the inquiry, in terms of the applicability of ETSU and so on. So happy to respond to any specific queries, but I don't think there's anything in particular that I would like to raise. I think you're on mute again, I'm afraid.
It's me that's failing here. Sorry about that. Trainer, anything in particular that you haven't had answers on during the hearing yesterday or today that you raised in your submission that you would like to highlight to us as reporters, and therefore maybe we ask a question of the developers? Ms. Trainer.
Sorry, I muted myself. I think I still fail to understand when ETSU clearly says that, first of all, engagement with local people is crucial, that if there's a likelihood that complaints will be made, that consent should not be given. The question that I raised regarding the hub heights, which James, whom I've met numerous times, has said is not relevant to this application. I think it's relevant because there's a cumulative impact has been assessed, including Hadgard Hill extension. I'm not explaining this very well. If mistakes or inaccuracies existed in the Hadgard Hill extension noise assessments, then these are then being applied to the cumulative noise assessments for all three of these applications. I don't know if I'm correct in that, but that's the way it seems to me. The hub heights, if the hub heights were questionable for the Hadgard Hill extension, which I've got all this in our submission, so I'm not going to go into detail. If the hub heights were questionable, then all the subsequent assessments that were taken using those hub heights, in other words, the location of the turbines, the elevation of the turbines for the Hadgard Hill extension, these are then applied to any subsequent data that is used for any three of these developments, in my view. I also can't understand how Mr. Mackay, sorry, James, can say that Knockcronal, I don't know how you pronounced it, James, it wasn't Knockcronal, was not collected during periods of storms. The Knockcronal data, which was NML1, which was being used as proxy for us initially, was collected during periods of storms. And I've included an email from Mr. Hacking at Knockcronal to, I forget who it was, but he's saying that it was collected during periods of extreme weather. And ETSU is quite clear that atypical weather patterns should not be used to collect data for background noise monitoring. That's what I fail to understand. In my view, 5 major storms hitting the UK during the period when the noise monitoring was done here. It wasn't just the burn, bear and spate that would influence the figures. They were huge storms that caused massive damage across the whole of the UK. And the noise monitoring was done during that period, which doesn't make sense to me, that can be considered acceptable. I don't think I can say anything else. Also, the snowfall was not taken out as was not extracted from the data, which was used for Dobbingstone. So to say that the noise level for Dobbingstone and Knockcronal would be the same, in my view, they wouldn't. Knockcronal is a busier farm. It's got a huge cattle shed with 80 cows in it. It's got farm traffic going up and down every day to feed the cattle, to muck out the sheds. We have none of that. And to say that the Knockcronal figures tallied with the Dobbingstone figures, to my mind, doesn't make any sense. Because it was done, the Knockcronal survey was done during periods of extreme weather.
I think Mr. Mackay has had his hand up to respond to a couple of those points, Trainer, so we'll let him do that just now. Okay. Mr. Mackay. Thank you. You're on mute now, Mr. Mackay. Sorry for that.
I'll use double mute. Yes, I'll try and deal with those points. Again, I mean, I would note that the points were most of these points were dealt with in the letter that I've mentioned and discussed with ACON, but just for clarity, in relation to hub heights and turbine locations, any questions regarding the exact locations of the Hadgard Hill extension turbines aren't relevant to this inquiry. New predictions have been undertaken by all three applicants based on the turbine conditions that are being proposed. In relation to the storms, broadly speaking, there's two ways in which storm data or data collected during a storm could influence the measured levels. The first one is it is likely to result in much higher wind speeds being recorded. But that is a fundamental part of any SOR 97 noise assessment and is clearly visible on the graphs. So the fact that it was particularly windy during the survey period is exactly, sometimes we need to extend ground noise surveys undertaken for wind farms to ensure we do record periods of high wind speeds. So it's a key element of the baseline noise assessment and something that's fully taken into account during the regression process. Again, we looked at one of those scatter graphs in the session earlier on today. So the fact that background noise varies with wind speed as you get more wind in the trees and so on is one of the things that an ETSU R97 baseline assessment is seeking to record and quantify, which I'm confident that the assessment did. The second way in which data collected during a storm could be affected is in relation to the impact of rain. Both rain directly in terms of perhaps a drip. I know it was something we discussed with Ms. Traynor at the time, was noise running off the guttering and down the drains around her property during periods of rainfall. Again, it's explained in the letter the approach we undertook to account for that. We adopted rainfall data collected at three locations. We combined all of those data sets together, and then we removed any data that was recorded during a 10-minute period where rain occurred. We also removed the 10-minute period before that, accounting for the fact that often tipping bucket rain gauges are used, so it might take a small amount of time for that to fill up before it tips. So we got rid of that data set too. As we detailed in the letter, we also removed data for the 10-minute period after that to take an even more cautious approach. So that should help to account for any influence of direct rain. The point about the river being in spate again was covered in a bit of detail. The river, elevated river levels can influence background noise data. That was one of the reasons why we included the time series data in the graph, so that could be seen, and the telltale banding of data, which I would suggest is usually associated with assessments undertaken where a river is dominant, were not apparent in the scatter graphs. The difference or the similarity between measurements undertaken at Knockcronal and the data collected at Dobingston, there are a range of factors which influence background noise measurements. I recall, but please correct me if I'm wrong, Ms. Traynor, I recall there being a concern about whether cows mooing would potentially elevate levels, noting that can occur for potentially a prolonged period. That's an inherent part of the soundscape, not rocker. Apologies if my pronunciation is still incorrect. But again, that was whilst TNEI didn't feel that would have a material impact on the measured levels, because of the fact that we use the LA90 parameter, which looks at the quietest 10% of data. We still undertook those additional measurements at Dobingston to account for any potential difference in background noise levels in both areas. So yeah, I think, as I say, I totally appreciate the concerns. I appreciate the concerns as they were raised at the time. I have always tried to be transparent with the approach we've taken to try and reassure Ms. Traynor and others. Appreciate it's a highly technical subject, but I would note that this was all discussed in detail as well with the council's appointed noise advisor, who was also happy with the approach, having reviewed all the information I've discussed and covered briefly today in quite some detail.
Thank you very much, Mr. Mackay. We've heard your response, Ms. General. You know, we have given you the opportunity to highlight your key concerns, which you've done, and you've heard the response. We've also got the written material to go back to. You highlighted one of the areas that you were leaving over to the next item was with regard to complaints. So I think I'm happy to move on to item 9 on the agenda. And I've entitled it Noise Complaints to South Ayrshire Council, but with regard to the submissions of Save Straighten Scotland and others, there are a number of points made with regard to the level of complaints and the enforcement of complaints in particular, and a suggestion in the comments made that those complaints may not be addressed appropriately, and that should be taken into account in our consideration of these applications. Perhaps I could turn to Ms. Crossway just to kind of summarise your main points that you want to make in this hearing with regard to noise complaints. I mean, the council did respond to our further written submissions, which you'll have seen. But I'd be really keen if you try to summarise your main points that you feel would be useful to have a discussion on today, and we can get the responses of the applicants in terms of the significance or otherwise of those points.
I think it's the veracity of the council is questionable, and also the claims made in the Craiginmoddie noise report at 766. And they state in respect of the claims of Hadyard Hill Wind Farm.
May I ask which reference that would, which CD number that was for?
It's in our report, CD02, our main report, 1702, and at paragraph 4.1 on page 5.
Yeah.
I don't need to read out the whole quote, but basically they are denying on South Ayrshire's behalf that Hadyard Hill Wind Farm hasn't been shut off at various times. We never claimed that all the turbines were off at the same time. I don't know that particular thing, but I have presented lots of evidence that the turbines have been off at various times for various reasons. And I've presented the evidence in the complaints. We have in this area 685 households registered in the area of Straighton Bar, Daly and Cross Hill. Now Cross Hill might be slightly out with this area, but it's not very far out with this area. And impacts on these homes depend on the locations and the topography. And if we go to this same report of ours, if we go to paragraph 3.1, and it's paragraph 6, and we've put in various freedom of informations over the years to Hadyard here, to South Ayrshire Council about complaints since 2017, when we started working together on the health effects. And they sent me a folder with about 80 complaints in it, which I have submitted as evidence. And some of these show just how badly the council has actually acted on any of these complaints. It says in my report how many of these complaints have been satisfactorily resolved in favour of the complainant. And South Ayrshire Council's answer is this information is not recorded, but we can advise the complainer to keep in touch if there are further problems and the service request is closed after 3 months. Now, we have extensive complaints from Casey Dell, and she sent an updated statement to say that she still pays council tax on her home because she, although they've had to abandon it in 2016, they did not want their home to go to Trelawney Wind Farm. And she explains just from the time that Hadyard Hill turbine started operating, life became unacceptable. She states the same sort of problems that Mrs. Holmes referred to this morning. She said that there were also problems of the infrasound as well as audible, which took time to manifest in the form of headaches, depression and lethargy, breathing difficulties. And she said that they intended to spend a considerable amount of money on their home, but instead decided to move away and buy something. By spring 2015, it became impossible to live in our house, and we used the modernisation cash to co-purchase a house near our son in Merseyside. We asked both SSE and South Ayrshire Council to monitor the noise levels, but their efforts were less than wholehearted. In SSE case, the monitoring equipment mysteriously failed during the noisiest period of the survey, and even then the report showed that noise levels were broken. I'm not going to go through all these because you've got them to read, but I would just like to refer to David Baldwin's home. That he submitted a video which we've given you the link to, which is actually on the Save Straighton website, about how all the problems in their home. The wind turbine noise has had negative health on several members of our family. These include lack of sleep and poor quality sleep, leading to lethargy, stress, depression, and an increase in the frequency of migraines and headaches. We complained to South Ayrshire Environmental Health Department first in 2006. However, at that time, and still somewhat to this date, they have very little experience in dealing with wind issues. And he goes on to explain that I have included an Appendix 1, which is included in the evidence I've submitted. This, by the way, is all in CD 1703. It's called Witness Statement, South Ayrshire Council Complaints. And so he includes Appendix 1, which describes the process we had to go through to eventually get turbine noise monitoring carried out at our home. And it was a very, very lengthy process. And there's 2 pages of it for you to look at. And then we have the evidence from Pat Spence. And this was not to do with Hadyard Hill directly, although she does feel that maybe it influences the cumulative effect influences her. But again, she has suffered and it has never been resolved. She's had ongoing complaints ever since the Aracleop turbines were switched on in 2013. And then it got worse with Kilgalliack, and it continues to get worse. And now she is in a position where, since also during the intervening period, the symptoms previously described have not just continued but worsened. When I eat a meal, particularly in the evening, the turbine switched on with a vengeance, the effect being that I effectively become a liquidizer and prisoner in the smallest room until every morsel has passed through my system. This happens up to 3 or 4 times a week through the winter, less in summer. And she's complained to the environmental health officers. They're ongoing. She phones, she emails. They say they'll come, they don't come, and they just basically ignore her. What I'm trying to demonstrate here is that the time taken for these people to complain, and for anything at all to be done about it, and even when monitoring goes in, it sometimes is there for a year, and then it can take months before a report is forthcoming. And then when it's found that the turbines are compliant, because as we know, everything is measured on a 10-minute average. So even though you might have a loud noise, like a gunshot, the gunshot noise would then be averaged into a 10-minute section. So you wouldn't actually get that noise. You would just get an average of a noise. And that is the problem with DBA. It averages out everything. And then the wind turbine companies appear to be compliant often. So the noise complaints never get resolved. And although it was very, very considerate of I can't remember which person yesterday, the lawyer yesterday, who said, Mr. Vincent, I'm not sure whether it was Mr. McEwen, anyway, said that there isn't, you can actually take out a private noise nuisance case. These are incredibly expensive to do. Even to get a lawyer's letter costs at least £200 and maybe up to 2,000 in the case that we've just had recently. When monitoring is done, and as happened in the, if you go to page 11 of 1703, we have an instance of a noise abatement case being brought forward. Now, again, it said in the Craiginmoddie that they didn't know of any noise abatement assessments, but we have one here, and we have the physical evidence of it. It seems it was never brought forward because of a technicality. Apparently, it was sent to the wrong department. Now, I have no idea why that stops a noise abatement notice from going forward. I would have thought it would have been resent to the right department. But then on page 12 and 13, we can read just a few of the extracts, and all I will probably in the documentation coming forward that we're going to do, I will organise these to include much more of them, because I now think that these are associated with the new evidence that was presented. And we see at the end a stream of emails, and at the end, South Ayrshire Councils just says, can I politely remind you one more time that the council has issued its final consideration of your complaint and has nothing further to add. We will not enter into further correspondence with either of you on this matter. I hope this clarifies the matter. I don't think that is South Ayrshire Council dealing properly with situations to do with wind turbines, and I do worry that the conditions, as already stated by EPSUR 97 or the Good Practice Guide, allow any way for anything to improve unless we actually add conditions in that will include timely process, and also conditions that will include, as Mr. Hooson said, it needs to include the SCADA data, and it needs to include much more open and transparency. We also have an ongoing situation, which I would just like to bring Mr. Grosvenor in on briefly as well, which also illustrates what we're trying to say.
Yeah, can I refer you to CD 17006? And also paragraph 6.4 in our inquiry report, which is number 1702. And paragraph 6.4, the ongoing and currently unresolved wind turbine noise nuisance case in respect to the Blary Hill Wind Power Station is having a devastating impact on the affected residents to the same extent. This is the relevance of this. To the same extent of the Hadyard Hill residents at reference 53603 above. Now, we've already got evidence that there was a submission of part of the complaints where one of the residents ended up in hospital. That's been replicated currently. I'm not going to say too much about the case because it's ongoing and there's client confidentiality in here. But the point is that we're now in a position where we can say emphatically conditions don't work, complaints don't work, and we've got a proposal here for 3 large, powerful wind power plants of 35 turbines up to 200 meters high. We've seen what's happened at Hunterston. Those complaints have been alleviated because the turbines have been removed. But our position is, and we will say this quite firmly, conditions don't work. ETSU obviously isn't providing adequate protection, regardless of whether it's infrasound, low frequency, audible noise. And as Ms. Traynor has actually said, you know, she's living with noisy turbines at Hadyard Hill. You can argue about whether they're compliant or not. We would perhaps suggest they're not. So as we see from this inquiry, the developers' acousticians are basically saying, well, it's business as usual. It's all compliant. You can consent. And unfortunately, it's the residents that have to pick up the tab. We've got a local authority, specifically at South Ayrshire Council, which seems unable to deal with complaints effectively and in a timely manner. The residents' suffering continues. In the case of Pat Spence, it's still unresolved. It's ongoing. This cannot be an acceptable position. Now, it's up to the reporters in this particular conjoined inquiry to, to write your report to reflect this. But we are deeply concerned that we're in a situation where turbines potentially will be consented. And we're not saying there will be guaranteed complaints. We can't prejudge the outcome of that. But based on current evidence, it's highly likely that there will be. And those complaints will not be resolved for long periods of time, if at all.
Microphone, Mr. Bray.
You're on mute.
Yeah. With regard to the council, I think you referred to the word veracity with regard to their approach. You've obviously got concerns about that. How are we to deal with your complaints with the council? We're considering this on behalf of ministers with regard to making recommendations to them through this inquiry. You have clearly issues with the local authority. You don't think they're doing their job, is what you're saying to me. I have no comment to make on that. How are we to consider that within the context of making recommendations to ministers?
Well, I don't just think this is about just South Ayrshire Council. It's not South Ayrshire Council that we're dealing with in other authorities. I think this is happening throughout Scotland. I think that it is partly to do with the conditions, and the conditions need to be strengthened, and they need to be more than just about ETSU R97. They need to be about the health and the well-being of the people. And one suggested in Dumfries and Galloway with people that we're working with, one resident suggested that if there are serious health impacts at someone's home, then the turbine should be shut down until it's resolved. It would help enormously with the people that we're working with in another part of the country. All the developer has to do is shut the turbines down for 3 or 4 weeks to give the people respite, and then switch on the turbines, the furthest one away, and maybe build up, and then find which turbines are causing the problem. It might not be all of them. It might, you know, it's the fact that the wind industry is not investigating the areas where there are problems. If the wind industry and Public Health Scotland got together and actually did some studying on homes close to these industrial turbines, this could be resolved.
You have also referred to evidence which you're, I think it's 1703, which adds to your evidence with regard to the medical impact, for want of a better phrase. So that was the two things I took out of that discussion, is that you've a concern about conditions, and then those complaints add to your evidence submitted on the medical implications. It probably leads us to a discussion on conditions. And we're now happy to leave item 10 till the end, since we're starting to talk about conditions, because you seem to have suggested there that, notwithstanding your view on the proposals in the broadest sense, but with regard to noise, at the very least, any future consents should have different conditions. So I'm quite happy to talk through now item 11, and in particular your submission. I think that's CD 1717. Ms. Taylor, you have your hand up, sorry.
Yes, I wanted to give you the background on the complaints which we lodged with regard to.
Yeah.
It's okay to do that now?
Yes, do that now. That was my fault. I should have come to you.
Oh, no, it's fine. I think it was 2016, 2017. Now, our experience has been different from the experience that Susan has been describing. And it's and maybe pertinent to you just by your final comments there. It was about 2016, 2017. We started to get noise from the existing Hagyard Hill turbines, which was unbearable. It was a whomping and a roaring. You couldn't go outside. We go to a place which is about half a mile from the house where we do a lot of wildlife photographing. We couldn't be there because it was just so bad. It was so loud, and it was the whomping through your whole body. We raised complaints. We raised them with South Ayrshire, and we also raised them with SSE. Now, this takes me back to what I've said about the Craiginmoddie proposal to some extent. Instead of going through South Ayrshire and harassing the life out of South Ayrshire, because you raise a complaint with them, they then say, well, we'll send somebody out, but they won't be at work until Tuesday. They're on leave. All right, well, the noise might not be there next Tuesday. So that happens all the time. So instead of doing that, we liaised directly with SSE. The noise manager at that time was a woman called Claire McEwen, whom James knows. And I explained the problem to her. She then asked me to record the times that we were getting that particular horrible noise. I then logged that, gave it to her. She then put that to the manager of the wind farm, who then did a subsequent, I don't know what you call it, a survey of what was happening with the turbines at those particular times. They then identified that there was a specific issue at that time, and this is all in our submission. They could identify the wind speed, the wind direction, and it was when they were constrained off due to grid not being able to take the power. They then identified a method of fixing that where it would be trialled. It was supposed to be trialled and it wasn't, which meant that we got further incidences of the same type of noise. That then was automated. The system to correct it, in other words, shut down the turbines near us, there's 6 of them. They shut them down under those particular conditions: wind direction, wind speed, and constraint. They all get shut down, and we have not had that noise since that was done. But that was dependent on the relationships that we had with the SSE and with the managers on site. And that came from their initial engagement with us through the whole process. James has said that they came out and had meetings with us. We were able to build relationships with these people, which meant that we could liaise directly with them and bypass South Ayrshire. That's a concern for us right now, because Craiginmoddie have not engaged with us at all, or anybody else in the local community. We also have the direct phone number for the manager for the existing Hagyard Hill site. So if there is a problem, we phone him directly and he'll be here in 5 minutes. They've already been out many years ago, because it only takes them 5-10 minutes to get from there to here to see what the problem is. So SSE agreed that as good neighbours, they didn't admit that the constraint, that the limit was being broken. What they said was that as good neighbours, they would agree to shut these turbines down under those conditions to stop us being exposed to that horrible, unbearable noise. So in terms of what you're saying, what can you do about South Ayrshire? If the developers take the time to build relationships with local people and provide them with relevant information, then it gives a better avenue for people to get complaints dealt with, and dealt with fairly quickly. It took a year for us to get that automated. But since it's been automated, we have not had any further problems with regard to that particular noise. I hope that's helpful.
Thank you, Mr. Chair. I think Ms. Crosby also wanted to come in.
Yes, we're very pleased to hear that from Ms. Traynor, but unfortunately, in our experience, which is becoming extensive, this is not the norm. We're trying to liaise with the operators of other wind turbines throughout Scotland, and certainly in the case I've just mentioned, where the operators are singularly uncooperative, and basically we're having to pursue the normal avenues, and I can't say any more than that. So we're pleased that that's happening with Hagyard Hill, and maybe that's good practice that should come forth. But the problem we have here, let's just cut to the chase. You know, when we've got acousticians basically saying that people complaining because of non-acoustic factors, or because it's psychogenic, or a whole host of other claims that basically deny what people are saying, or refute what people are saying. This is not conducive. And it's no wonder that people are fearful. And our position is quite clear. You know, we're not saying we're opposing development of wind turbines, but our position at the moment is that we cannot see a way forward when we've got, you know, an impasse, which is where we are now, where the acousticians are saying everything's fine, but the evidence on the ground relatively to people living near turbines getting larger and larger isn't borne out by ETSU itself and the protection that ETSU is supposed to provide. ETSU, unfortunately, is failing. And as Professor Alves Pereira said, you know, if government policy is failing to protect local residents, then where do we go from here? And we're sorry that, you know, we are talking about the same conundrum, but we don't want to be having these conversations ongoing, because we unfortunately have to work with the people who are suffering and who are having to pick up the tabs. And it's serious. It's beyond serious. It's quite critical now. And we can't stress that strongly enough.
Thank you, Mr. Grosvenor, making that point, and where I was going on to say that part of your submission is that conditions may be, in your view, may be able to address that, and your document 1717 is your submissions on noise conditions, and it's those I'd like to kind of chat through to see what you're offering and get the applicant's responses with regard to the issues that you've just set out. I'm conscious that it's 3 o'clock, we've been going for an hour. We'll probably just take a 5-minute break, just a 5-minute comfort break, if that's okay, and then we'll come back at 5 past, just to allow you a short break to discuss the conditions, in particular the conditions document put forward by Save Straighten for Scotland. And we may not be able to get into discussion on the council's view because the council are not part of this hearing, but they will be a part of the conditions hearing. So we'll see you at 5 past. Okay, can I check that everyone has returned from that short break? Certainly.
Yeah.
Can't see this crossway quite yet.
Yeah, sorry, I haven't switched
That's
my
fine.
video on.
That's fine. Okay, can I quickly just ask, since we're talking about conditions, ask the applicants, in terms of the conditions in general, noise was left as a bit of a blank on the table because it was a separate, rather long condition. But I think there was further discussion with the council ongoing, and I know we are having another hearing, but is there an update with regard to what the position is from the council on noise conditions? Or is it as their amendments that I think that they made to a draft condition some time ago? Or has there been a further discussion or anything further from the council in advance of the conditions hearing? I don't know if any of the applicants' representatives can give me anything on that.
Sorry, go on, Mr. Fraser.
Well, what I've just been told is there is no update, I'm afraid, at the moment. There's been no further discussion that I'm aware of. I think Mr. Mackay is nodding.
That's useful. So there is an ongoing discussion, and there is a final draft condition which has been drafted by the applicants. The council have made some comments on earlier versions with regard to amplitude modulation and perhaps other matters, but we will, because the council are not part of this, then we can't go into their comments, I think, today without the council being here to discuss them. So what we do have today is Safe Straight for Scotland's document, which is CD 1717, and that was proposals for noise conditions. I must admit that I did have a little bit of difficulty in just establishing what the conditions were that you were proposing, but just the way it was kind of set out, it's certainly clear that you were looking for the Dundrook wind farm condition 20, which we talked about earlier on, to be applied. But perhaps it would be useful if you could just highlight, Ms. Crossway, or others representing you, which conditions in that document you think should apply to one or all of these applications in front of us.
Could I hand over to Mr. Hooson on this, and then maybe myself or Professor Marianne Alves Pereira might come in at the end as well.
Mr. Hooson.
Okay, well, just to summarise the general issues with regards to setting conditions, when it comes to investigating a complaint or testing compliance, often it's passed over to the developer's acoustic consultants to do the investigation. They follow ETSU as appropriate in this circumstance. And they are provided with data from SCADA, the supervisory control and data acquisition systems in the wind farm. And that, incidentally, is a suggestion that's been agreed between the council and the developers as being an appropriate condition, where things such as arithmetic mean hub height wind speed in meters per second measured or derived from one or more met masts is collected. Arithmetic mean hub height wind direction, nacelle anemometer wind speeds, nacelle orientation, in other words, how it's pointing towards the wind or not. Arithmetic.
Referring to there? document is that? You were referring to a
Um,
document that had been agreed between the council and the applicants. Can I just have the reference? Is it 1530?
Yeah, yes, that's right. CD 015.030.
Yeah, that's fine. Just wanted to check.
So all I'm looking at is note 1 in that, and the only thing that I would emphasize with regards to that data being provided is that it's provided to the consultant that works for the wind farm operator. Now, one of the things that I would hope that would be in a condition would be that such data is also made available to any independent consultant that might want to investigate issues of compliance or nuisance complaint. The way this is...
Well, we'll just deal with that point just since you've raised it, just as you come along. I think Mr. Jiggins put his hand up. So, Mr. Jiggins?
Yes, thank you, Mr. Bray. I just wanted to come back on that point that referring to CD 1530, that paragraph A of that document makes it clear that those data can be provided to the council on request within 14 days of such a request. And I wanted to stress that the intention of the conditions should be, and it was the intention that we wanted, was that it should be possible for an independent person to do this type of compliance assessment. The council usually is in the position to do that sort of action. They may well contract another party to do that on their behalf, such as APCON in this case, if it were South Ayrshire, for example. But that certainly should be possible following the conditions that are proposed. And I would agree that that should be feasible to do.
Okay, so that's a response to that point, Mr. Hewson. I think you're going to go on to another point.
Well, just following on those comments there from Mr. Jiggins, note 1A in this document doesn't say anything about it's the responsibility of council to request the data. All I'm suggesting in a condition would be that it should be made available to an independent consultant, not just a consultant employed by the developers.
I think in terms of what you were referring to was potentially the guidance notes. What was referring to was the first page, which was the actual condition. Is that fair, Mr. Jiggins?
Yeah, I was looking at the item A, which is the wind farm operator shall provide this data in comma separated values electronic format to the local planning authority on its request within 14 days of receipt in writing of such a request. That's a standalone condition. If a third party wanted access to the data, they could simply ask the local authority to ask for it on their behalf. I see no problem with that in third parties doing that. I would welcome it. You know, that's entirely the purpose of that sentence.
Okay. Mr. Hewson, you can move on to
yes. My comment on that is quite simply, I've seen this condition in the past, and it has been very difficult in the past to get planning or local authorities to actually make those requests. So if the condition could be worded in such a way that the planning or local planning authority must also provide upon request from an individual investigating a complaint, for example, then that would assist, I think. Yes, at the moment.
That's now a matter that the council would have to answer, so I can't speak on their behalf.
Yes, all I'm saying is that Safe Strait and Sky, our position would be that it would be nice to have a condition that enforces the council to get the information if it's requested for an independent investigation.
Yeah, I've taken note of that. Other points, Mr. Hewson, with regard to the types of condition or amendments to condition that you would propose?
Well, it's not necessarily amendments to the CDO 15030. It's just in relation to the conditions that have been proposed in this document from Safe Straighten for Scotland. Basically, we would hope that when any investigation of compliance is done, that audio recordings are taken, and that the audio recordings are continuous, not just in short sample periods of each 10-minute section. I've regularly done this, and equipment I've got can run for 3 weeks and continuously record audio. So it's perfectly feasible to do continuous audio recordings. So that's one of the conditions that one would hope to have included. Some monitoring equipment has the capability of measuring rather low frequencies. Other monitoring equipment, it's possible to adjust the low frequency response. So for instance, the Duo sound level meter from 01dB, it's possible to set the lower frequency at which it records data down to 6.3 Hertz. But equally, you can actually set it higher. So one of the things I would hope is that equipment suitable to measure to low frequencies in the infrasound region is possible with the equipment, rather than being cut off at, say, 20 Hertz.
Mr. Mackay, you've raised your hand, and so has Mr. Jiggins. So I'll let Mr. Mackay go first.
Thank you. Yeah, my point was really in relation to the need for continuous sound recordings. The requirement for the sound recordings, as set out in the conditions, is to inform the tonal noise assessment principally. And the procedure outlined for that specifically requires the use of a 2-minute sample. So that is what's required to undertake the condition. Whilst I would agree with Mr. Husson that it might be nice to have continuous sound recordings, my experience of the data requirements for such monitoring is slightly different. I think it depends on the equipment that you're using and the exact parameters that you're recording. But I've certainly worked with some sound level meters which are full within 1 week if you record all the data that's possibly available. And I think in the event of a compliance monitoring assessment being undertaken, that would result in memory cards being filled up very quickly. So I think my point is, whilst, in a perfect world, if storage just wasn't an issue, that might be nice. I would say it's not necessary. It's not necessary to discharge the condition. It's not necessary to do the tonal noise assessment. And occasionally it is useful to go back and listen to those recordings to say, well, actually, I can hear that this was going on during the time, or so that data isn't valid. Usually anything that's going to affect those measurements that's significant would be present in a 2-minute sample every 10 minutes. So just to note that whilst I think it would be a nice to have, I don't think it's necessary. And I would suggest that the wording remains as written.
Jiggins.
Yes,
I
would concur with that point. I think it's overly onerous to require continuous audio recordings. And as Mr. Mackay said, you can, generally speaking, hear any effects in the 2-minute recording. And to require 5 times as much data to be gathered, just simply for what reason, I'm not sure, is a nice to have, but there are practical implications.
Mr. Houston, you were going to come in.
Yes, all I would like to say on that point is that, yes, 2-minute audio recordings is a minimum requirement. There's nothing in ETSU that says you can't record for longer. And if it is of benefit and can give you extra information, for example, I think Ms. Traynor mentioned that she experienced lots of whoomp type sounds, whoomp, whoomp, and so on. Those things are transient and don't occur all the time. So if you're just doing a 2-minute snapshot and only getting 20% of the data, it may miss out on those events which could be significant in assessing the special audible characteristics, such as impulsivity or amplitude modulation.
Mr. Jiggins again.
Again, I'd come back to necessity. In terms of ET197, yes, you could gather more data than you need to. But if you need to gather a certain level of data and there are practical implications for gathering more than that, then you have to consider whether that's really necessary. And I don't think it is. And in terms of these transient effects, if they're so transient that you would miss them by them not being in the 2-minute period and a 10-minute period, then they're so transient that they're maybe not often enough to really be a problem. I think in my experience, where you've got problems of special audio characteristics, shall we call them for the moment, then they are persistent through a 10-minute period, generally speaking, except that some things like amplitude modulation can come and go, but generally where they're more of a problem is where they're more continuous, and you will find that in the 2-minute period. However, I would come back to the need for that, given that we're suggesting that there's not a need for a condition to control amplitude modulation necessarily, but that's another one that we can come on to.
Mr. Crosby, if you did have your hand up, I was just allowing Mr. Jiggins to respond directly to Mr. Houston, so I wasn't ignoring you.
I just wanted to ask the question: if the requirements are so small by the wind companies, why do they put in the noise monitoring equipment for months at a time? We have the situation ongoing with TNEI at the moment in a property and monitoring close to Mark Hill. It's been there for at least 4 or 5 months, and it was the same as another property. It was there for nearly a year. I would have thought it would have been much better to do what Mr. Houston said and have a 3-week spell, a continuous 3-week spell, and then, well, that's what common sense says to me. I'm not an acoustician.
Mr. McCoy, a short response for that, is it? You might be on mute again. I've had the same problem, don't worry.
Well, treble muted. I didn't know that was a thing. Apologies. I'm not in a position to talk about that case, which is ongoing. But what I can say is where extended noise compliance monitoring has been required, in my experience, that usually relates to the conditions which are need to be recorded. And there's a couple of factors which can influence that. The first of which is complaints logs, which are often undertaken by residents. I think Ms. Traynor actually referred to one earlier, where if a resident can identify particular periods which during which they thought the noise was unacceptable, that can be used and related back to the operation of the wind farm. Now, depending on how frequently those particular conditions were to occur, it can take quite some time to replicate that. For example, if it's a very high wind speed from the northeast, for example, that occurs very infrequently. So it can take quite some time to record the same conditions, which is ultimately what we're trying to do, to replicate the conditions that occurred during the period of complaints. Another factor which can influence the assessment is the operation of the wind farm. Occasionally certain wind farms aren't fully operational. That might be because certain turbines are shut down to alleviate shadow flicker. It might be routine maintenance. There are a number of factors which might mean all turbines aren't operational. When we undertake compliance monitoring, we seek to do that during wind conditions where the wind farm is operating normally. So that's another factor which needs to take into account. And if you combine both of those, and if you're looking for a high wind speed when the wind is coming from an unusual wind direction, and you're trying to do that in a period where all wind turbines are operational, unfortunately, it can take a long time to replicate those conditions. I would note that in my experience, compliance surveys generally last 2 to 3 months. Ms. Crosthwaite is quite quite right. In certain cases, it can last longer than that. But again, in my experience, having 10 minutes of audio recording would not have shortened any of those assessments.
Mr. Houston, were you going to the, that was the condition with regard to 10 to 20-minute sound files, I think. Were you going on to the next condition, which I think it's it says 4 analysis on page 2. Is that where you're moving to in terms of the proposed conditions?
What I'd like to mention next is making sure that there's a calibration tone that's recorded onto some wave files at the start of a survey and at the end of a survey, to make sure that each set of wave file recordings are correctly have the ability to be calibrated. So it's a simple thing to do. When you set the equipment up at the outset, you put your calibrator on and ensure that the wave file is being recorded with the calibrator on, and you do the same at the end when you collect the equipment, just so that you have a reference point for your wave files that are being recorded throughout the survey. So that's the calibration tone. It's suggested here in part F that you do this at least once a week. I don't think that's necessary. In accordance with ETSU, it's not required, but a calibration tone would be useful. A lot of these conditions relate to instrumentation that isn't required within ETSU. These are wish lists should there be an investigation of infrasound with regards to measuring down to the lowest blade pass frequency, for instance. So although ETSU is only considered with audible sound, it won't be possible for typical sound level meters to do the recordings down at 1 hertz. That's a condition that wouldn't necessarily comply with ETSU, but it's a wish list that it would be nice to have.
And that's with regard to the first 3 tables of your document, where you have requirements and rationale in tables. Are they all related to that point?
It's measurement requirements parts in that there's a table requirement and rationale, and it's itemized A, B, C, D, E, F, G, and H. The other thing is that a GPS location can be noted when it's deployed and collected. I have sound level meters that have GPS units within them, and they continuously record the GPS location, but they don't produce a timestamp on the each recording necessarily. It can be done, and it again is a wish list, but that could be enabled by suitable note taking at the deployment and collection of the equipment.
Okay, I'll let you carry on. Is there anything else on that table down to H before I'm taking Mr. Jiggins?
Sorry, we're waiting for Mr. Jenkins, or?
Oh, no, I just asked you. Sorry, I maybe wasn't talking directly to the microphone. I was maybe talking to my keyboard. I was just asking whether or not you had anything else to add with regard to measurement requirements A to H, and before Mr. Jiggins came in.
Yes, there's just one final comment. I've experienced where an investigator recently has done audio recordings of a wind farm to check a complainant, and what they did was set a weighting on the wave file recording. So the wave file itself was a weighted. So when you come to listen to a wave file to see what's on it, it then gets a weighted again by your ear. So it's just has one of the things that any WAV files that are recorded have to be unweighted, just to ensure that that doesn't happen.
Mr. Jiggins, any response to the requirements set out in A to H?
Okay, there are a lot of requirements there, which Mr. Hudson describes as a wish list. Many of them seem to be centered around specific requirements of instrumentation. And so I see problems there in them being applied to the general measurement of noise and investigation, and allowing consultants to use equipment that may be available to them. Many of these requirements seem to be related to things that the SAM Scribe 2 system does, things like recording WAV files in certain formats, having calibration tones recorded within WAV files, timestamps, non-proprietary formats. So I see that this would have restrictions, unreasonable restrictions on the choice of equipment that could be used, and may preclude free use of normal sound level meters that would be otherwise perfectly acceptable to undertake an ETSO 97 assessment. So I couldn't agree that all these things are actually requirements, because they don't really aid in doing an ETSO 97 assessment, as far as I can tell.
Carrick?
Thank you. Yeah, yeah, I concur with what Mr. Jiggins has just said, but also echo something that Mr. Hewson said, which is effectively that both of these tables, really, in sections 3 and 4 of this document, are really designed to enable the measurements of the types of issues that are related to the infrasound matters that we've already discussed, and to accept the requirements that we're looking at, the technical requirements here, would really be sort of tacit acceptance of the rest of the evidence on those points, and we don't accept those points. And so we don't see that there's any necessity for any of these technical requirements to support measurements made in compliance with the guidance.
And one final point from me, sir. Mr. Hewson indicated that these were a wish list and a nice to have on a couple of occasions. He said that that wouldn't comply with ETSU guidance. It also wouldn't comply with Scottish Government policy on conditions. Nice to haves are not permitted under the circular. Only where matters are required should they be imposed in conditions. And we say they're certainly not required in this case.
So Hewson, do you want to go on, not to explain in detail, but maybe just to pull out key points from the rest of the document, so that I can ask the students to respond. I don't know if you want to take us through the second table or not, which is only A to D, or if you just want to pull out any key points from the document before I turn to the applicants.
Okay, well, section 4 analysis is not part of the requirements of ETSU necessarily, so I don't see those as being required within a condition. It's something that an investigator can do, but it's not necessarily to have in a condition to be a requirement to do. Okay, so that's with regards to section 4 of the analysis. One of the things I'd like to mention, though, is in regard to data that's collected, whether the WAV files are in 2 minutes per 10-minute sample or for the full 10-minute sample in each sample, it would be very useful if the data could not be stamped as confidential and could be provided for third-party independent review. that would allow Section 4 analysis to be done by others to see if there's anything else in there that might shed light upon, let's say, the instance of a complaint.
Against your hand up.
It was just on that point there. I've never known data be provided to local authorities or third parties that was regarded as confidential information that was been put into a compliance assessment that then becomes a matter of public record. The raw data that went to form the basis of that report is also therefore a matter of public record, and as acousticians we're required to provide that for third parties to look at if they so wish. So I don't really see that there's a confidentiality restriction on data. My experience is that data has been provided without that restriction. So I'm not sure why that would apply in this case. Certainly not in the conditions that are proposed here.
Yes, they're not proposed in these conditions, and I'm suggesting that a condition be provided to ensure that this data that's collected does not come under the banner of confidentiality, especially since it might be recorded at a resident's property. It's recording audio on their property, so in effect, it's actually their information at the end of the day. So the subsequent data analysis from someone to do an independent check, I think, is a valid thing to consider. And I have experience of a number of wind farms within Australia where every time you request the data for independent analysis, it's been couched under the legal terms of that's confidential, you can't have it. So that's the only reason for the suggestion that it might apply in this set of conditions.
Mr. Jiggins, do you want to come back on that?
I just reiterate that maybe what happens in Australia is different to what happens in the UK, but my experience is that data has been provided when it's been requested, and it's not been provided under any sort of confidentiality agreement, non-disclosure agreement, or any other such agreement. It's been provided to those who've requested it where it's been requested, as far as I'm aware.
Okay, thank you, Mr. Jiggins.
Yes, so all that I would suggest is that we make that absolutely sure in the form of a condition to make sure that that is possible and not going to be at the whim of a developer circumvented.
Okay, we have that point. Are you moving on to, I think?
Mr. Rovner would like to say something.
Unfortunately, in reference to Mr. Jiggins' comments, that's not our experience. Our experience is in the UK mirrors that of Mr. Hewson. So we would, I would say, challenge it or dispute it, but it's not our experience. We find it we found great difficulty in getting this information, important information from developers or operators when we're dealing with compliance testing or compliance results. So we would urge that condition to be put in.
We have on page 3, Mr. Houston, we have discussed and you've put forward your thoughts on protection for camping and campsites and noise limits and targets. I think we've had a fairly thorough discussion on those. So page 3 is section 5, 6, 6.1 and 7. And the suggested condition to protect campers. I think that
Mr. Wright, could I just, before we move on to that section, could I make a comment on the previous table?
If you wish.
Yeah, it's just to reiterate what Mr. Mr. Lintinger said, and the Carrick applicant's representative, when referring to those requirements shown under section 4, which would similarly be that there are things which are not required to do an assessment according to X 197. So they're not required, as far as we're concerned, to comply with government policy.
If I could just comment, I agree that they're not required as a condition. The issue here is that anyone who's got the WAV file recordings that are suitably calibrated can do whatever analysis they wish. And that table indicates some of those that Save Straighten for Scotland might wish to do on their behalf. And again, I don't see those as being a condition.
So if I could just clarify then that we're happy that they're something which Safe Straight are not requesting to be part of the conditions.
Well, that's my view, but I don't know if Crossweight has any comment on that.
Well, we are looking to strengthen the conditions to protect the health and well-being of the people who will be living close to these turbines. And if the applicants are so sure that their turbines will be safely operational, then I don't see why they should refuse to gather data that can be examined by ourselves and other third parties, and those who are complaining should be, it theoretically should belong to them anyway, and they should be able to ask anyone that they wish to analyse it for them. I don't see why they wouldn't be prepared to do unweighted measurements and prove to us all that their turbines are so safe. This is why I would like them included. I would like to extend the ETSU 97 conditions in good faith to protect the health and well-being of all those residents in the future who might be affected.
Thank you, Ms. Crossway. I'm sorry if I was rushing you all along there to the campsite, but I think there are a couple of sections there that deal with what builds up to a suggested condition to protect campers. Now we've had that discussion. The wording for a condition is set out there on page 4. Do we need to have a further discussion? I think I've got the parties' views on that. Mr. Houston, you've indicated earlier on when we went through your hearing statement that it was your view that a condition be set. Is there anything additional from our discussion earlier on that you would like to add?
No, there's nothing I'd like to add on that section. So noise sensitive receivers, as you have here in section 6 and 7, basically is what I would like to see as a form of condition. Then unless there's questions from the applicants, we could go on to condition to assess amplitude modulation.
So if I could just raise two points. The first of those is that I want to be clear whether or not it's been suggested that the extraneous matters are to be included in a condition or not, because there seemed to be a division of opinion. And I think if you're going to make submissions in due course, I'd like to know on behalf of Craiginmoddie what the position is. Secondly, in relation to camping, I think the way I've seen that dealt with before, you've got the submissions in relation to dwellings, is that there is a reference to a use class, and that is a permanent residential use class in the condition. As you know, we don't think that a condition looking at tenting or caravanning is required. So the way to deal with that is the other way around, is to restrict it to dwellings fought by the use class definition.
Just to comment on that, South Ayrshire Council in their guideline suggests that camping sites should be considered separately, and also as a normal full-time dwelling. So I think we disagree on that, and it's up to the reporters to decide one way or the other.
Yeah.
Well, we disagree. I mean, in no circumstances is a tenanted dwelling, and that, you know, if that becomes a matter for legal submissions, I'm very secure on that. So the way we're suggesting is you do that is you tie them to ETSU. That's a dwelling, and you do that by restricting it to the definition of use class.
Mr. Hardy, I think
Again,
what Mr. Hardy was looking for is clarification on section 4, the analysis and the table below it, whether or not Safe State Scotland were indicating that all of these requirements were a condition. I think Mr. Houston said they don't necessarily need to be a condition. What seemed to come out from this Crossway submission was that the availability of data and for not to be confidential is the key matter that she would want in a condition, unless I've picked it up wrong, and that you would want all of these requirements in a planning condition, Ms. Crossway. That's under 4 analysis at the end of page 2 and the beginning of page 3, the table A to E.
I think your first analysis is correct. Obviously, this is a wish list. We understand that the developers are not going to comply with all these things, but we would request to go as far as possible to protect the health and well-being and to make the conditions as strong as possible. Again, making them available to third party, that they're not confidential, and that they are unweighted if possible. And also, I think the calibration point is very valid too.
I've heard your reviews on that, and I think Mr. Houston, you were going to take us to amplitude modulation, and when there's culminates, I think, yes, in terms of your proposal is to use a condition which we've already discussed. I think we might ask for the complete decision for Denbrook Wind Farm. I think Ms. Leaven mentioned that earlier on today. So that condition 20, your submissions culminate in recommending that condition. Is there anything additional you would like to say before I open that up to the applicants? Suffice to say that there may be further discussion there will be further discussion at the planning conditions hearing with the council. So we can only take this so far today.
Yes, the preamble to the condition that I'm suggesting quite simply refers to the Institute of Acoustics' preferred method for assessing amplitude modulation. And my extensive analysis on the application of that shows that, and that's what this detail is all about, is that it's only applicable to single wind turbines and not to multiple turbines. So it's not very useful as a method to apply to a wind farm. So one of the suggestions from ACON, who's the consultants for SAC, have suggested that such an approach might be used. And the reason that I've explained why you shouldn't use it is expanded here in the section all up to my recommended condition, which shows how ineffective the Institute of Acoustics method is for multiple turbines.
I think today and perhaps yesterday as well, I think I've heard the view, and I think I clarified with the applicants that they were all of a view that they saw no particular need for a condition. I think that's accurate. So in principle, can I just double check with the applicants that is their position based on their evidence? There's no particular need, so it's an in principle sort of view first. And if that's the case, then there may not be a need for you to question some of the content of the condition, even though I might have a question or two. Mr. Mackay.
Well, thank you, sir. I appreciate that you're not wanting to drag this into a long technical discussion, but I just wanted to flag. Appreciate you might come back to this in the conditions session. Unfortunately, that's during the period of holiday that Mr. Hardy referred to earlier on, so I won't be able to attend that. In my absence, I would, if I may, like to draw your attention to the sections discussing an AM condition in my hearing statement. So that's core document 1226, and I discuss it in paragraphs 8.9 onwards. Would be happy to go into that in detail, but fundamentally, I would agree with you that I have said that I don't think a condition dealing with AM would be appropriate, and I've set out in detail in that section my rationale behind coming to that decision. So, thank you.
Thank you for that reference back to your hearing statement. Any of the other applicants want to flag anything with regard to the matter in principle?
Just to say, sir, we endorse what Mr. McKay's just said and what's in his hearing statement as well. We don't believe that an AM condition is necessary. We think it will be necessary to discuss this at the condition session with the council, and in fairness, probably won't say very much more about the principal issue at this stage, because the council will need to hear that and make their own submissions on the point as well.
Mr. Jiggins, anything from you?
Yeah, I would draw your attention to my hearing statement, which is CD 1514 in paragraph 4.6, where I cover that in response to third parties and provide a commentary on that subject. I think there's two issues here. One is there a need in principle for an AM condition? And then there's another point, which is if one might accept that there's a need to control AM, by which method might you choose to do that? And so whilst we maintain that there may not be a need to impose an AM condition, if you were minded to do so, we would be very much opposed to a condition formulated along the lines that Mr. Hutton has suggested. Whilst Mr. Hutton has found an example there where the IOA AM metric does not adequately, as he puts it, represent the true peak to trough difference. There'll always be examples you can find where that's the case. But on the whole, what we find with the IOA AM metric, and this is a methodology come up with by the Institute of Acoustics, following on from the imposition of this Denbrook condition on Denbrook Wind Farm, and the evolution of the techniques and technology in detecting AM, the AM metric that the IOA came up with was the objective method of doing so. The point of doing it was to come up with a method which had minimized the amount of false positives, or the amount of AM that was falsely determined as AM, which wasn't related to wind turbines. And so if you were minded to impose an AM condition, we would very much strongly recommend the IOA method, as we're all members of the IOA. That is the method that we would commend to you. And it's technically possible, therefore, to formulate an AM condition along those lines. But then I go back to my first point, which is, do we accept that there's not a principle, that there is a principle to impose one, and that remains as a rejection of that. So those are the two aspects I wanted to raise, but I will defer to my colleagues who have got more to say on this, I'm sure.
Yeah, I think we might have all seen that there's 5 minutes left of the meeting. I hope Callum's listening and that we don't abruptly end the meeting and it will continue to run on before 4 o'clock. So if Callum is listening, he can reset the clock. Ms. Crosby, you have a number 1 beside your hand, so I'm going to go to you first.
With all respect, our position is that whether it's an IOA condition, which we'd leave for Mr. Hooson to discuss, our position, firm position, is that it's essential that there is an AM condition. We would prefer the Denbrook condition, but our position is unequivocal on this point.
And I think I've seen in in evidence reference to other planning consents, but I'm not sure that they've been submitted. And they did refer to other planning consents in Scotland with conditions. Can you elaborate on that, or in fact any of the participants today, but partially with regard to safe straighting for Scotland? Is there planning conditions out there that have been dealt with it on appeal, for example, or for other Section 36 applications that have covered AM that you could refer us to?
If we could possibly come back on that one, we will. We're aware that they are, but we can't just tell you. But our concern. I know I'm not an acoustician, but I am a geographer, and I do understand topography. And we already have Hadyard Hill, and we already have Desalloch. We have Kirkhill coming up that's not being considered, and there's also Slentook in the background. And the topography, these turbines are all going to be at different heights. There's definitely going to be a need for an EAM.
Thank you. Well, we may consider, and the fellow parties are content, not looking necessarily for any commentary, but any submission and any Scottish consents that have such conditions, because I think it has been mentioned in your submissions. I'll come to you in a minute, Mr. Houston, but I'm going to go to Carrick first because they have a number 2 beside them.
Thank you. Yes, I just wanted to add to the statement made by Mr. Jiggins a moment ago in relation to AM conditions. Just wanted to first draw your attention to our hearing statements at CD 1227, particularly paragraphs 98 to 113. Which describes the direction that research into AM has gone, particularly addressing how different metrics have been developed. And so Mr. Houston has provided some technical criticism around the IOA metric, but the development of that metric followed a review which was undertaken in 2015 of existing methods. And that review included the approach that Mr. Houston prefers, which we're describing as the Denbrook Condition 20. And that condition was proposed in 2009. And the IOA working group noted in their review in 2015 that the Denbrook method was not based on any research publications, and it was controversial because it fails to discern wind turbine sound from any other type of fluctuating sound. And at the time of the Denbrook condition imposition, both the applicant in that case and the objector groups that both opposed the condition 20 imposition and petitioned to have it replaced due to a range of concerns about its drafting, which were both technical and legal. And following the eventual appeal decision, there was then 6 years of arguments between the applicant, the objectors, the council, and various English courts over how Condition 20 should be interpreted and applied. I'll just add that a considerable amount of research into AM and AM measurements has since been undertaken since 2009, when the Condition 20 was originally drafted, and much of that is discussed in our in the Bayes report, which is CD 1215. In particular, I would draw your attention to document pages 117 to 127, which is PDF pages 132 to 142, and particularly focusing on measurement methods, which are discussed in document pages 119 to 120, which is PDF pages 134 to 135. So to summarise, I think that the Denbrook Wind Farm Condition 20, which was drafted in 2009, was long before any of the recent research developments. In my view, it's not fit for purpose, and it doesn't reflect any of the advancements in understanding that have come to pass subsequently. Thank you.
I'm looking to see who's next. I think it was Mr. Mackay who was next, and then I'll come to you, Mr. Houston.
Thank you. I would like to agree with Mr. Latinga's statements there regarding the Denbrook condition. I also believe it's wholly inappropriate. largely due to the false positives. But I actually think this takes me back to a point I've made in my evidence, and I know I've already given you those references, but specifically in relation to paragraph 8.13. In that paragraph, I explain that two elements are required to construct a planning condition to consider AM. A method to objectively quantify the levels of AM is the first point. And the second point is information setting out what level of AM is acceptable / detailing the guidance setting out how AM should be penalised in any assessment. Now, both of those points are discussed in detail in the subsequent paragraphs, but just to be clear, the Denbrook condition does identify a method to quantify levels of AM, albeit I don't think it does it very successfully, because as Mr. Latinga's just mentioned, it can be triggered by things like birdsong. In my opinion, I do agree with Mr. Jiggins that the IOA AM metric provides a better methodology to quantify AM. But I think the key point here is the second point that I've made, is we don't have enough information to detail how that quantification should be interpreted. There's no government endorsed information to say what level of AM is acceptable or unacceptable. And in particular, I've referenced elsewhere in my hearing statement how one might balance out the frequency of occurrence, how often AM might occur, versus the severity of any AM. And there's not sufficient information, in my opinion, to quantify that. If I might just point to one further reference in my statement to which relates to that, it's paragraph 8.19, which takes us back to the WSP Bayes report. And that says, it has been noted that the interaction effects observed in experimental studies between AM depth and overall sound level imply that a penalty for AM based on AM depth should decrease in magnitude as level increases. However, it's also been noted that further evidence is needed to understand this effect, and that it could be problematic to represent this in a penalty scheme. That document is very recent, and it clearly explains the point that I've just made. So, again, to reiterate, I would suggest that an AM condition is inappropriate.
So, Houston, bring you in now. I know you've been waiting for a little while.
Mr. Mackay is right that the Institute of Acoustics AM method is just a method to give you a number from an analysis of a period of measurement. The sample that I provided was just one of thousands, and it was not an unusual one where I chose the worst case. There are many worse cases than that. So, Mr. Jiggins, just to address your issue, it wasn't a worst case that I chose out of 1,000. There were many thousands like that. All it was showing was that the ETSU requirement is to assess amplitude modulation, and it defines what that amplitude modulation is. It's the peak to trough value. The Institute of Acoustics AM method produces a value, but it is not the peak to trough necessarily. The method was designed to actually attempt to get around false positives. So let's say you have birdsong. If birdsong in the morning chorus is occurring, you might get peaks from the birdsong, and you shouldn't be considering that as being amplitude modulation from the wind farm. So certainly that is one of the benefits of doing the Institute of Acoustics method. However, you have to weigh the positives with the negatives. It also gives you false positives as well as false negatives. So it's not a perfect method. The most perfect method is the one from Denbrook, whereby you do audio recordings, you scan the audio recordings, you pick out the peak to trough values, you actually listen to the audio recordings, and you can tell if it's birdsong or not, or if it's a wind farm. And it's very simple in its method and its application. And the beauty of it is that there's a penalty scheme also associated with it. And the other advantage of that thing is that it's been verified all the way up through the High Court, through multiple courts, and has been issued and tested in legislation. So from my point of view, it's a perfectly workable condition. It's current, it's operating, and it's easy to apply. And the idea of false positives is easily overcome by listening to the audio samples, which you have to record.
Mr. Mackay, I think you had your hand up first, and then Mr. Jiggins.
Thank you. I guess there's a couple of points I'd like to raise in response to that. In relation to Mr. Husson's point about the IOA metric according the appropriate peak to trough level in a sample, and I think that's made in reference to the figure on page 8 of core document 1717, I believe. I would note that in some respects that's irrelevant, given my point about a penalty scheme or levels of acceptability or unacceptability. Let's say, for argument's sake, Mr. Husson believes that the correct peak to trough value for that should be 3 dB and the IOA metric has it as 4 dB. Ultimately, that is irrelevant, given that we don't know and we haven't got a penalty system to assign to those values. And the penalty system referred to in relation to the Denbrook condition is based on even less evidence than the one that has been linked to the IOA metric. As Mr. Latinga mentioned, that condition came out 14 years ago now. And as far as I'm aware, it hasn't been imposed again at an appeal. Again, I would reiterate that condition is wholly inappropriate in my opinion.
Mr. Jiggins.
Thank you. Yes, I just wanted to highlight the fact that the condition as written, you could get a very, very short period of AM that would trigger that condition and show that the wind farm was in breach of its planning conditions with basically 5 minutes or 6 minutes of data. So one period of 6 minutes of data of high levels of AM above 3 dB would be all that was required for a wind farm to be in breach of condition. We've got no idea and no relationship, as Mr. Mackay has said and Mr. Latinga has said, that in any way relates to the acceptability or not of wind turbine AM. But nonetheless, that is what it says, and that is what would trigger a non-compliance with that condition. It's extremely unreasonable to impose that condition as written, and I can't represent my aversion to it strongly enough.
Yeah, well, before I bring in Carrick, I think Mr. MacLeod has raised hand. I think we've possibly taken the discussion as far as we can. I am conscious that the council have got views on this. I don't want to prejudice their discussion any more than we have done today with regard to our discussion. I've heard your views. I was keen to hear the technical experts' views and Save Straighten for Scotland, because I don't think they have indicated that they'll be involved in the conditions hearing unless we've got that wrong. So I'm certainly keen to hear that today, and we'll hear from the council. But Mr. MacLeod, you're going to raise something on behalf of Carrick.
Thank you, sir. It's just one final point, and it has been touched on already this afternoon. So one of Save Straighten for Scotland's documents is CD 17.1003, and it's the witness statements, the unresolved complaints. And I appreciate that they have issues with the way that the council has handled complaints and so on. But I just wanted to draw your attention to the copies of the noise abatement notices that were served incorrectly on Scottish and Southern Energy PLC. So that's page 11 of CD 17.1003. And if you have that, the bottom box, which shows the abatement notice itself, describes what nuisance the council had found at that point in time. and that was amplitude modulation of noise emitted from turbines next to, and then the property is blanked out, affecting use by the occupiers of their amenity space around the property, etc., is reasonably tolerable to the occupiers. And then the requirement was to operate the turbines next to that property in such a manner that reduces amplified modulation of the wind turbine noise to a level that does not give rise to a statutory nuisance within a set period of time. And the reason that I mention that is simply to illustrate that whilst I think all the applicants are at one here, there is no appropriate policy guidance you can go to say what a condition should look like on AM at the moment. What you can see from this is that the local authority does have powers to take action where AM is an issue in practice. And again, I reiterate the point I made yesterday, which is just because something hasn't been fully conditioned as part of this process doesn't mean that local people cannot achieve an outcome if AM is unacceptable to them.
Thanks for that. Well, not ask for your views on the local authority, Ms. Cosby, on that one, because I think you've stated your views there on that. But it does take us neatly to the comment that Ms. McLeod made yesterday on item, which was item 10, which was just the relevance of the Bald Hills wind farm judgment, and you highlighted yesterday your thoughts on that. And before we conclude today, I was just wanting to offer anyone the opportunity to comment further on that Bald Hills judgment in terms of relevance. Heard from the Carrick applicant yesterday. I think we had
Sir,
lots of noise there for a minute, but I think we're okay. Mr. Hardy.
Yes, if I may, just before we move on to that, in a sense, it feels a little bit like a throwback. I've not had anybody argue for Denbrook for a long time. Maybe there are legal submissions to make on that, and I just want to put a marker down. What was said about it being tested through the English courts isn't something that we accept, not in the way that it's been portrayed, certainly. So can I don't think it's appropriate to go into that anymore now, but if I could just put a marker down that may be something that I'd like to put legal submissions in, whether that's to before the conditions session, that might be helpful, or whether indeed that's at the end of the inquiry sessions. So it's just to leave a marker there.
Thank you for that, Mr. Hardy. You may find that when we come to wrapping up this afternoon, I may indicate that we may ask for further written submissions on more than what we've indicated so far. Right. Because there's obviously there's a few things there that we might want to tie up. Right. And that might be one of them.
Well, if I can add lawfulness and legal wrangles over previous iterations of an AM condition, then if I could add that to the list, that would be super.
Mr. Crosby, you have your hand up. Was it to kind of talk about the Balls Hill wind farm judgment?
Well, just before you go on to that, I would like to say that Safe Straighten would like to participate in the conditions session, please. I hadn't realised that we hadn't been invited to that, or that we hadn't stated that we would like to be participants.
I think originally you did at the first EEM meeting, but we didn't get anything else after that, I don't think, unless we missed something. But you have made submissions on conditions, so I don't have a particular problem with that, given that it's a number of days away. But we will inform the parties of that view, and I think that will assist the discussion on noise conditions. Anyone else got anything to say about the Balls Hill wind farm? We heard yesterday on it. Anything else?
Mr. Hooson would like to. He has some comments on it.
Well, just quite simply that I was involved in that case as an expert witness, and My involvement in that case started in 2017, and it was only decided in 2022. So it lasted quite a number of years before the complaints were addressed. It went through many court cases, not just the final one, and it involved quite extensive legal actions against the local council for inaction and so on and so forth, objections and appeals by the wind farm operator against decisions by the council. It ran on and on and on, and the complainant, Mr. John Zakula and Noel Uren, I would say almost got bankrupted in the cost of the proceedings. So it's just an indication that having a simple nuisance catch-all in conditions isn't really very practical for the average person who's exposed to wind farm noise.
Someone else wanted to make a comment on that judgment. It is obviously out with our jurisdiction, but we have it as part of the core documents. I think something else from Carrick.
Yeah, just a very quick response to that, sir. The Australian legal system is obviously very different to the highly efficient and cost-effective Scottish legal system. I mentioned yesterday the availability of legal aid. I'm certainly not encouraging people to go down that route, but legal aid would be available, I am sure. And the second point is that if someone was looking to raise statutory nuisance action, it's done by way of summary application to the Sheriff Court, and it's deliberately done that way. Summary applications are the simplest form of action, apart from small claims, obviously, but the simplest form of action that can be raised in the Sheriff Court. And it's not uncommon for people to raise summary actions on their own without the involvement of lawyers, if that's an issue. So I simply make that point for those who might not be aware.
Thank you for that. Mr. Fraser, the last word perhaps before we wrap up.
I'm not trying to get the last word, sir, but I have to say I struggle to know what that case, what you're being invited to make of that case. Obviously, the point has been made, it's a different jurisdiction, so whilst there may be some similarities with respect to the law, it isn't the law that applies in Scotland. But secondly, it's very much a case on its own facts and also on whatever the evidence was that was presented before the court. So I really struggle to see how it provides any real assistance to the determinations you have to make or the recommendations you have to make to the Scottish ministers. And of course, the point has already been made and was made yesterday that the planning system and the consent procedure isn't the only way that the public are protected, because there is the protection through the nuisance actions that can be taken in the courts as well. So I haven't said anything more on it because, as I say, I struggle to see how it really assists at all and what it's really being put forward for. Thank you, sir.
Thank you, Mr. Fraser. Ms. Crosby?
Well, I'd just like to say that the whole point of it is to state that wind turbines should be there isn't a problem with net zero and having wind turbines, but they should be able to exist alongside people still being able to get a good night's sleep, and they shouldn't prevent that or be instead of that. That is the whole point of it was the judge's rulings, and it's quoted in my report. I can't tell you exactly where it is because I've my computer was getting a bit hot and I had to close down a lot of my pages, but it's there. If you look it up, Bald Hills, you'll see exactly what he said, and I'm sure that Mr. Hewson can quote it to you.
Mr. Fraser.
I think I've heard the various accusations you've given the evidence to the inquiry over the last 2 days make the very point that that is exactly what ETSU is there to do. So there's nobody arguing about people not being entitled to sleep soundly, so to speak. But we have a procedure already, which is well known and used throughout the country, applying ETSU, as Mr. Diggins and all the other gentlemen have explained.
And I think we did go through those arguments, I think, yesterday. I think it was under item 3. We went through those arguments. So I am going to draw today's this hearing's discussion to a close. It has been slightly unusual in that we have allowed participants to make statements, but I think that's fair in the circumstances. I didn't see any objection from any of the parties, so hopefully everyone will have had their say and made their points. Before I make some concluding remarks about the rest of the inquiry, Mrs. Leven or Mr. Reid, do you have any questions related to what we've discussed today? I'm not hearing anything. So, well, I've content I've asked all the questions and facilitated a discussion that you've made the points you want to make. We will follow this up with a further written submissions procedure. We'll collect what we committed to ask for, and we'll put that in a notice. We will also consider whether or not there is a need to ask for more on conditions, and that relates to Mr. Hardy's point. So please expect that to come out. We'll have to just consider how that relates to the planning conditions hearing, of course. I mean, it may be the case that it may be better to wait until we've had that hearing as well and get all the information that we're going to require after that hearing. But we'll clarify that in the procedure notice, rather than guessing what we might do this afternoon. We'll think about it properly first. The next scheduled element of this inquiry is actually a accompanied site visit to Dobbington Farm. Ms. Traynor, and I hope you will recall that on Monday at 10 o'clock, which the council has led the arrangements for, but I do hope they have been in touch and you are aware of all the arrangements, Ms. Traynor. Since you're there, I'm quite happy to ask you that.
Yes, I am, and I would advise you to bring Majiri repellent.
We'll take that. We'll take that advice on board. After that, on Tuesday, there is an evening hearing on landscape and visual matters. That's in the Carrick Centre at 6:30 to 8:30. And I think the agenda's just gone out for that, and a virtual hearing on private water supplies on the 7th, and then transportation on the 8th. So a busy week next week. But for today, thank you very much, and for yesterday for your participation. I see a hand. Have I got something wrong there?
No, sir. Everything you've said is entirely correct, I think. I just wanted to flag 2 things. One was potentially making next week slightly busier, and that relates to the Peat session. We've been in discussions with SEPA in connection with the Carrick Peat session, and the morning of 9th of June is looking like a possibility. We'll drop you an email to confirm that, but I just wanted to flag that while we're on the call to you this afternoon. It may, of course, be that it's not suitable for the reporters, but I just wanted to mention that. And sorry,
as far as I'm aware, but we'll clarify that offline.
Okay. And then the second thing, and I'll not go into detail, but there is an email that's been sent to you this afternoon, copied to the other parties involved in the aviation session, currently scheduled for the end of June, and regrettably, it looks as if we're going to have to ask for a postponement of that session. I've spoken to both Mr. Hardy, representing Craiginmoddie, and also to Mr. Brown, who's representing the airport. The email will explain in a bit more detail current thinking, but again, I just wanted to flag that to you at the earliest opportunity.
Thank you for that. And with 3 wind farms and a life out there, it was always going to be difficult to make sure we stuck to programmes. So we'll be as accommodating as we can, and depending upon the circumstances. If there isn't anything else that anyone else would like to raise about the proceedings that are coming forward, I just thought I would summarise them for you for next week. So I've done that, and all I've got to say is good afternoon. Enjoy the rest of the afternoon if it's sunshine with you, and we'll see some of you next week. In particular, Mr. Trainer, we'll see you on Monday at 10 o'clock.
Thank you very much.